Let us pray. Almighty God, we willingly acknowledge you as the supreme being, most gracious and most merciful. Look down, we beseech you, on us who are members of this Senate, and deign to assist us in the duties that we have to perform on behalf of our beloved country of Trinidad and Tobago. Open our eyes to see the truth, and help us to accept it with all its implications into our lives. Direct us, O Lord, in our deliberations, so that setting aside private interests, unwholesome prejudices, and personal affections, we may treat all matters set before us with honesty, courage, and conviction. Through all we say and do in this Senate, may we give glory and honor to your holy name, inspire confidence in our fellow citizens, and make a positive contribution to the peace and prosperity of our nation. Amen.
By the President.
Honorable Senators, I have granted leave of absence to Senator Hazel Thompson, IE, who is out of the country. Honorable Senators, I have received the following correspondence from Her Excellency the President, Paula Mae Weeks, ORTT. The Constitution of the Republic of Trinidad and Tobago, by Her Excellency Paula Mae Weeks, ORTT, President of the Republic of Trinidad and Tobago and Commander-in-Chief of the Armed Forces. To Ms. Zola L. Phillips. Whereas Senator Hazel Thompson, IE, is incapable of performing her duties as a senator by reason of her absence from Trinidad and Tobago. Now, therefore, I, Paula Mae Weeks, President as aforesaid, in exercise of the power vested in me by Section 44(1)(a) and Section 44(4)(c) of the Constitution of the Republic of Trinidad and Tobago, do hereby appoint you, Zola L. Phillips, to be a member of the Senate temporarily with effect from the 11th of February 2020 and continuing during the absence from Trinidad and Tobago of Senator Hazel Thompson, IE. Given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the Office of the President St. Anne's this 10th day of February 2020. Honorable Senators, a senator is required to take the oath.
I, Zola Phillips, having been appointed a Member of Parliament, do swear by Almighty God that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter.
Papers.
Minister in the Ministry of Finance.
Madam President, I have the honour to lay on the table the following papers as listed on the order paper in the name of the Minister of Finance. The annual audited financial statements of the National Information and Communication Technology Company Limited, IGOVTT, for the financial year ended September 30, 2019, and the annual audited financial statements of Taurus Services Limited for the financial years ended September 30, 2017 and 2018. Thank you, Madam President.
Minister of Trade and Industry.
Madam President, I have the honour to lay on the table the following papers as listed on the order paper in my name. The Annual Administrative Report of the InvestET Limited for the years ended September 30th, 2015, 2016 and 2017. The Annual Report of the Trinidad and Tobago Bureau of Standards for the periods 2013 to 2014, 2014 to 2015 and 2015 to 2016. Thank you.
Minister of Works and Transport. Leader of Government Business.
Thank you very much, Madam President. Madam President, I have the honor to lay on the table the following papers as listed on the order paper in the name of the Minister of Works and Transport. The ministerial response of the Ministry of Works and Transport to the 19th report of the Public Administration and Appropriations Committee on the examination of the expenditure and internal controls of the Ministry of Works and Transport.
Leader of Government Business.
Different title. Madam President, I have the honor to lay on the table the following papers as listed on the supplemental order paper in the name of the Attorney General. The Strategic Services Agency Personnel Regulations 2020, the Strategic Service Agency's Regulations 2020.
Urgent questions.
Senator Mark.
Madam President, to the Honorable Minister of Education. Given the pleas for help from teachers of a school in Barataria, San Juan, which is described as being a war zone, can the Minister indicate what is being done to address this situation?
Minister of Education.
Thank you very much, Madam President. Madam President, I am appalled and dismayed by this question. The question asks about a school in the Barataria, Sawa area. That is a very large area. I don't know which school is being referred to. There are a number of schools, early childhood centers, there are a number of primary schools, and there are a number of secondary schools. Senator Mark needs to be more specific. If he identifies a particular school, I'd be more than happy to answer his question. Thank you very much.
Senator Mark.
Madam President, the Honorable Minister is aware of the school, and for purposes of not trying to stigmatize the particular school, we would like the Honorable Minister to indicate whether he's aware of any school that is involved in activities that is causing grave harm and bringing great discomfort to teachers as well as students. Madam President, can the Honorable Minister indicate, Madam President?
Senator Mark, you simply repeating the original question asked. You have another question on this?
Madam President, can the Minister deny or confirm reports in the press concerning a school within that zone that is involved, that is the students of that school, is involved in activities that is in fact causing and generating some degree of discomfort, rather, to teachers as well as students. Is the Minister aware of that, Madam President?
Minister.
Thank you very much, Madam President. As I said before, this indefinite article that he is referring to, I don't know, A and. Tell me what school it is and I'll answer. Are you afraid to name the school? Once you name the school, I'll be very happy to answer you, Senator Mark. Thank you.
Senator Mark, next question.
To the Minister of Works and Transport. In light of protests by residents of Indian Walk, Maruga, concerning road conditions in their community, can the Minister advise as to what action is being taken to resolve same?
Minister of Works and Transport.
Madam President, I'll be very specific with this answer. Madam President, the Moruga Road Rehabilitation Project comprised 42 landslips, 4 bridges, and the rehabilitation of the existing roadway. Contracts were awarded for 29 landslips. 14 are completed, 15 are ongoing, and the remaining 13 are to commence shortly. There are also 3 bridges completed and 1 is ongoing. To date, the Pure unit has completed 8 kilometers of the 28 kilometer to be rehabilitated, that is the roadway. The remaining 20 kilometers would be executed in line with the completion of the remaining landslips. It is noteworthy that the protest action which took place yesterday was actually on one of the active landslip sites. As a result of this, the contractor was unable to continue work due to the hostility of the protesters. However, currently, work have recommenced under police supervision. Thank you.
Mark?
Madam President, could the Honourable Minister indicate whether criminal elements were largely responsible for bringing a halt to the works that had begun, causing protest action to be taken by residents of the particular community? Can the Minister clarify for this Honourable House?
Minister.
Madam President, we have had instances where contractors would have been approached by different groups in different areas. Moruga is one of those areas where we do have this challenge. However, on this specific project, I cannot confirm that is the issue.
Senator Mark?
Can the Minister confirm, or put it another way, Madam President, is the Minister aware that the Member of Parliament for that particular area, Moruga Tableland, Representative Lavelle, on his Facebook, indicated that criminal elements were responsible for that situation, resulting in a halt of works taking place on that project? Is the Minister aware of that?
Senator Mark, I won't allow that question. Next question, Senator Haynes.
To the Minister of National Security. In light of previous reports to the police about the abuse being suffered by an 8-year-old girl from Kelly Village, has an investigation been launched into the police's failure to report same to the Children's Authority?
Minister of National Security.
Thank you very much, Madam President. Madam President, information provided to me directly from Commissioner of Police is as follows. Reports made. The police have checked, including checks with the Child Protection Unit of the Trinidad and Tobago Police Service, and they show that no reports were made against Maynard, either at the MOVA or the Chaguanas police stations. There were 2 reports made against Maynard on September 10th, 2011, where he was arrested and charged with assaulting Miss Sonia Thomas and his 8-month-old daughter. That matter remained pending for years. There was a second report made on the 6th of April 2019 about threats and child neglect. This report was made by Celestine Oliver, the sister of Mr. Maynard, and it was investigated by the police as well as the Child Protection Unit, who spoke to family members. At the time, the 2 children in question were not living with Mr. Maynard, but were living with their grandmother at Kelly Village in Caroni. The children denied when interviewed that they were beaten, and there were no marks of violence borne upon the bodies. Checks with the Criminal Investigation Division of the Trinidad and Tobago Police Service also revealed that no reports were made. So therefore, the basis upon which this question was asked seems to be a false premise. In any event, on behalf of the government of Trinidad and Tobago, I would like to extend our sincerest condolences and sympathy to the family members of this young girl who met such a tragic end. The Commissioner of Police, as well as the Trinidad and Tobago Police Service, also extend their sympathy and say that there were no specific reports and that we have listed the two that were previously made.
Yeah. Senator Haynes.
Madam President, would any measures be put in place at the level of the executive to mitigate against something like this happening?
I'm sorry, I didn't hear what
Yes. Would any measures be put in place at the level of the executive to mitigate against such an occurrence happening?
Minister.
The Attorney General has surmised my first question. Is it the executive of the Trinidad and Tobago Police Service, or what executive are you referring to, if I may ask?
Government.
Of the government?
Yes.
So, Madam President, the government already has measures in place. There are a number of bodies that are responsible for actions such as this, including the Children's Authority. At the Ministry of National Security, we also have a child protection unit working along with the Trinidad and Tobago Police Service, the Children's Authority. So there are, in fact, already bodies charged with the responsibility to look after instances such as this.
Senator Haynes.
Yes. Thank you for your response. And given that this situation has occurred, would there be any measures put in place to bolster those organizations that you've just spoken about?
Minister.
Thank you very much. Madam President, it gives me the opportunity to plead with persons in our society who are aware that there may be instances of abuse against our women or children taking place to please report it. There are a number of confidential hotlines that they can call. Please call into those hotlines, and the police service and the bodies charged with the responsibility, including the Children's Authority and the Child Protection Unit, will do their utmost best to assist in those types of situations.
Questions on notice, questions for all answer.
Leader of Government Business.
Thank you very much, President. Madam President, as per usual, the government will be answering all questions on the order paper, on notice.
Senator Mark.
Thank you, Madam President. Question number 27 to the Minister of National Security.
Minister of National Security.
Thank you very much, Madam President. Madam President, this was a very strange question and not one grounded in fact, because according to the information provided by the Commissioner of Police, there has been no sudden resignation by Mr. Harold Phillip. In fact, Mr. Phillip was employed and functioned as one of our acting Deputy Commissioners of Police up to yesterday. So yesterday, on the 10th of February, he turned sick. He went on pre-retirement leave as he approaches his 60th birthday. So at no point in time did Mr. Phillip resign, and he has continued in his work up to yesterday when he went on pre-retirement leave.
Sometime last year, Mr. Harold Phillips did in fact threaten to resign owing to internal differences within the police service. Is the minister aware of this?
That question doesn't arise. Next question, Senator Mark.
Madam President, can the minister indicate whether he's aware at any material point in time during 2019 information reached his desk that Mr. Harold Phillip had threatened to tender his resignation and proceeded to do so?
That question.
Is the minister aware of that?
No, that question does not arise. You want to ask a next question? Okay, next question, Senator Mark.
Question number 35 to the Minister of Energy and Energy Industries.
Minister of Energy and Energy Industries.
Thank you very much, Madam President. Madam President, NCMA 1, which is the block referred to by Senator Mark, is operated by Shell Trinidad and Tobago Limited under a production sharing contract, a PSC. There is no set rate of return from PSCs. The minister receives a share of production or the value thereof based on the commercial terms agreed with the contractor. In the negotiations for the extension, the government achieved improved commercial terms. With regards to Roman 2, the NCMA 1 PSC was extended to 2035. It would have expired in the year 2022. And in response to Roman 3, an assurance of continued gas production during the extended term and access to the production facilities. These goals were achieved.
Senator Mark.
The minister indicated, Madam President, that there were improved commercial terms being achieved as a result of this extension of the license to 2035. Can the minister, Madam President, share with us, Honorable Senate, what were these improved commercial terms?
Minister.
The Honorable Senator keeps asking the same question every week. Last week, you asked about Shell's improved commercial terms. I outlined it in some great detail. I indicated to you the most significant aspect of the increased commercial terms was the new gas price. That was based on a basket of markets and is no longer pegged to the low Henry Hub price. It included 1/3 Brent, 1/3 the European market, and 1/3 the Chinese, Japanese, Korean market. And that single act increased the value of our production, the government share of the production sharing contract most significantly. Because as we have articulated over the last 2 years, the greatest leakage of revenue from this country was in the sale of LNG.
Senator Mark.
Can the government indicate through the minister, or can the minister indicate rather, whether the government sought to get more value in the renewed license, having regard to the fact it was due to be expired in 2020, and all assets returned to the people of TNT and not given back to Shell on a free plate or platter? Can you tell us?
Minister.
Madam President, oil assets are of no value, excuse me, unless you can produce oil. And to produce oil, you need capital. So while theoretically, when the lease expired, it comes back to the state. But it is this very company that had invested all the capital to create the infrastructure. So it makes more sense to extend the life of the contract. And in exploration and production scenarios, the gestation period for some of these projects are 5 to 10 years. So no company will sit with a license expiring in 2022 and invest in 2020. They need at least a 10-year cycle. So that's the basis of the negotiations. And in that context, this is standard procedure in the energy sector. And as I said, and let me reiterate again, our biggest value comes from the renewed gas pricing structure. Because at the end of the day, you only make revenue from one source, the sale of gas. You're selling nothing else. You're selling tamban ball or anything there, You're selling gas. Okay? And the new price structure for gas is what has bring significant and will bring significant value to Trinidad and Tobago.
President, since Shell would have recovered its total investment after 20 years or just under, can the minister indicate to this House whether the government had done a valuation of the assets of Shell in what is called the NCMA block before extending its license to 2035, Madam President?
Minister.
Yes, we did an evaluation. The value of an asset is twofold. The quantum of remaining reserves that is on the ground and the value of the infrastructure. The infrastructure has no value unless you can use it to transport gas. So in other words, the fundamental value of any license is the reserves of gas in the ground. And it's in that context we extended the contract because under a production sharing contract, there are two components. I don't want to over talk on this matter. Cost recovery gas and profit gas. So when the contractor is in the cost recovery phase, the quantum to the government is less. But when they've cleared out their cost recovery and in the profit phase, the government shares sometime in excess of 50% of that gas stream.
Madam President, could the Honourable Minister indicate to us what was the estimated value of the gas in the ground and the estimated value of the infrastructure that he just outlined in dollars and cents? Can we get that information?
Minister.
I'm going to take a deep breath. The estimate of gas in the ground. Nobody buys gas in the ground, you know. You have to produce the gas, and the sale of the gas has to do two things. Cover the capital cost to produce the gas. And then the profits, based on the production sharing contract, is shared between the government of Trinidad and Tobago and the operator, which is Shell. And the percentages of the split is really the basis of the negotiation of a production sharing contract.
Next question. No, Senator Mark, those are your 4 questions.
You run from the second part, you know.
Next question, Senator Mark.
Sellout, you know.
Bringing a temporary senator to ask.
Sellout. But anyway, we'll deal with you on the platform. Madam President, may I address you?
Question
number 36 to my honourable colleague, the Minister of Public Utilities.
Minister of Public Utilities.
Madam President, the management of its receivables, both WASA and TNTEC. In the management of its receivables, both WASA and TNTEC have adopted a multi-pronged strategy which includes the following. 1, appointment of a special team within the commercial departments dedicated to the recovery of the debt from government agencies and industrial customers. 2, establishment of payment arrangement plans with very large debtors, basically. 3, in the case of WASA, a moratorium was given by the company to customers with outstanding bills to come in and regularize their positions. Additionally, the Ministry of Public Utilities have been working closely in close collaboration with the Ministry of Finance to ensure adequate funding is made available in fiscal 2020 for the respective ministries and state agencies to meet their obligations to TNTEC and WASA within the budget, so that undue pressure is not placed on these two public utilities in terms of their cash flow. In addition, the Ministry of Finance is supplementing WASA's annual subventions where necessary. By way of an example, the Minister of Finance is in the process of finalizing a US $100 million loan to allow WASA to clear all its arrears payments owed to DesalCut for desalinated water and to allow WASA to have access to funding for future payments to DesalCut.
Senator Mark.
Then could the Minister indicate the biggest debtors to both WASA and TNTEC?
Minister.
Well, that would that will depend on, if you could be a little bit more specific when you say the biggest debtors as it relates to private sector companies. In the case of TNTEC, yes, the biggest debtor from a private sector perspective is DesalCut, and I would like to get an understanding as to other, in the case of the other, are you looking at private sector or public sector? Both, Honourable Minister. Well, Madam President...
No, but Senator Mark, I won't allow that question based on the question posed, original question posed. Next question, Senator Mark.
Do a next question on the same one?
Yes.
Yeah. Can the Minister indicate whether the government of Trinidad and Tobago owes WASA? Well, let me put it in the way, Madam President, can the Minister share with us, Honourable Parliament, whether the government of Trinidad and Tobago owes TNTEC, as an example, over $1 billion, with your ministry owing close to $100 million? Can you clarify that first?
Minister.
Madam President, one, well, you started with WASA TNTech. I have to be sure, I could assure you that it is not $1 billion that is owed, based on the information that is before me, but I will have to then check and see, so I wouldn't be able to say exactly. But yes, the government agencies, as I've mentioned, and it is normal business practice, I would say. It is normal business practice in the case of TNTech that customers, any accounts that you will have receivables. What I could tell you is that TNTech as a company has sales and revenue of over $3 billion, and their receivables are still, total receivables, that include private sector, government, is still less than 90-day sales. The threshold that is considered to be in management that you want to make sure is that 90-day sales, anything between 0 and 90, is considered to be current. So based on TNTech total sales of over $3.2 billion, their receivables at less than 90-day sales is within management standards and good practice for a utility company.
Through you, can I ask the Honourable Minister, how successful thus far has been the committee that has been appointed, as you have identified, in collecting outstanding debts owed to both WASA and TNTech by both the private and public sector? Can you tell us how successful this committee has been? Madam President, through you.
Minister.
I could say the performance of the committee and the performance of these two entities are a lot better than they were under the previous regime. That being said, in the case of, again, in the case of the performance of the company as it relates to WASA's debt, you see, you have to understand the two debts, they are different. In the case of WASA's debt, for example, a big part of what is being owed in the case of WASA debts, over 80%, is really residential customers. Government's billing to WASA is very small percentage, represents probably less than 10% of their receivables. So the activities, you might have noticed that there are a number of commercial buildings that we are now threatening to sell for outstanding payments as regards to WASA. So the committee is working, and there will be different approaches, depends on the different types of customers. But the big part of WASA's outstanding debt, really over 80% of the amount of money owed to people, receivables, is really residential customers. But again, to your specific question, the committee is working very diligently, all right, with targets, and they are meeting their targets that we have set for them in trying to improve the cash flow of these two important utilities.
Senator Mark.
President, is the minister aware that under the last regime, government agencies and ministries owed less than $100 million at the end of the 5-year cycle, as compared to what is taking place now, where government agencies and ministries owe TNTech over $1 billion. Are you aware of this,
Minister? Minister.
Madam Speaker, you know, as I said, Madam President, you know, cash flow situations and the way how cash flowed in the previous regime is a lot different from these times now. I mean, you know, we are aware of other projects, I could tell you, of $1.2 billion in cash being placed in the case of wastewater and NGC that could have then been used, plus a number of different ways. So you are talking about a time, Madam President, you are talking about a time when you had expenditure, right, where you were spending expenditure of over $63 billion.
Minister.
Of course you had a different cash flow.
Minister, Senator Mark, you posed a question, the minister is answering. Please allow him to answer the question. Please allow him. Please let us all, when someone is on their legs, listen to the person. Minister.
So, as I was saying, yes, you are talking about different times. $63 billion in expenditure versus what is being spent now, or what is available to be spent now. Over $20 billion less in revenue to be able to spend. And in addition to that, as I said, money was flowing like water then, and you had a lot of projects, SIS, a number of different people that were able to walk away with $1.2 billion. So therefore, cash flow was a lot different. We are managing in different times, and we are trying as best as possible to manage and keep the country afloat in light of over $20 billion drop in revenue.
Next question, Senator Mark.
Let's save 20 million.
Senator Mark,
Rental.
next question, please.
Don't enjoy.
So perhaps,
Yes.
Senator Mark,
Yeah,
please take your seat. Senator Mark, please. Let me just set the tone for today's sitting. It has already started to sort of stray from what is expected in this chamber. Senator Mark, I'm inviting you to pose your question concisely to the relevant minister. Senator
I
Mark.
am guided accordingly. Madam President, I bow to your ruling. Could you not disturb me, please? Madam President, may I address you and not be disturbed? Please. Madam President, question number 37 to the Honorable Minister of Labour and Small Enterprise Development, my good friend.
Minister of Labour and Small Enterprise Development.
Thank you very much, Madam President. And I trust, Senator Wademark, you will hear my response in its entirety without interrupting me. Madam President, the statement to which Senator Wademark made reference concerning Trinidad and Tobago having the 5th highest worker absenteeism rating in the world was made by an official of the Ministry of Labour and Small Enterprise Development at a workshop hosted by the Department of Labour of the Division of Community Development, Enterprise Development and Labour of the Tobago House of Assembly. The workshop titled Decent Work Agenda, Productivity and Managing Absenteeism was held on June 14, 2019. Prior to this, at a seminar on absenteeism in the workplace hosted by the Employers Consultative Association of Trinidad and Tobago, the information about Trinidad and Tobago's rating in worker absenteeism was revealed and published in the Business Guardian on January 21st, 2016 by Dr. Kwame R. Charles, Quality Consultants Limited. Madam President, absenteeism is regarded as one of the many workplaces issues that can contribute to low productivity, decreased revenue, and even lead to the detriment of the organization and negative impact on the overall development of the nation. In this regard, the National Productivity Council, which falls under the purview of the Ministry of Labour, was reconstituted on May 10, 2017, and has been working to fulfill its mandate, which includes, inter alia, 1, to promote and develop greater productivity and quality awareness and consciousness of the people of Trinidad and Tobago in collaboration with key stakeholders. 2, to inculcate new values and attitudes in Trinidad and Tobago regarding productivity, quality, and competitiveness. 3, to establish a system of documentation and dissemination of information relating to productivity. 4, to advise government on the formulation of national policies and strategies on all aspects of productivity, quality, and competitiveness. 5, to identify constraints to the improvement of productivity, quality, and competitiveness, and propose remedial measures to be taken. 6, to serve as a focal point on all matters pertaining to productivity, quality, and competitiveness. 7, to develop and adopt a set of key productivity indicators for Trinidad and Tobago. And 8, to design and conduct relevant productivity surveys. Madam President, in the pursuit of these objectives, in September 2019, Cabinet agreed that the National Productivity Council be tasked with the responsibility of collecting data on absenteeism measured in a consistent manner for comparison across sectors and industries, and with particular attention to absences around holidays. Data would also need to be collected on absenteeism in the public service as well as the state enterprises. Madam President, in addition, the Ministry of Labor and Small Enterprise Development, in addressing a range of workplace issues and in sensitizing employers and employees of their rights and responsibilities in the workplace, has embarked on a public sensitization campaign. This includes sharing of information via radio, television, and the print media. Additionally, in the public service, employees have access to free and confidential employees assistance programs where professional support and counseling is provided in helping employees address personal and professional challenges that may affect their attendance as well as their performance. Finally, Madam President, I look forward to the support of employers and workers as we work together to address the issue of worker absenteeism in Trinidad and Tobago and get the job done. Thank you.
Interrupt you. Madam President, may I assure you, ask the Honorable Minister, how far has the project involving estimating the losses to industry, revenue, productivity, overall development in the private sector, the public sector, and the state sector? How far has that project reached by the committee, National Productivity Council, that has been tasked by the Cabinet to get to the bottom of what is going on?
Minister.
Thank you, Madam President. Madam President, in my sharing of information, I did indicate that the National Productivity Council was recently reconstituted. That committee has held one meeting. The committee is chaired by Mr. Roger McLean, lecturer at the University of the West Indies, and I dare say by the second meeting of the committee, some work plan would emerge.
Mark?
Then can the Minister indicate whether she has given this body any timeline, given the urgency and the importance of this subject matter, to have an interim report submitted to the Minister and through her to the Cabinet? Have you given this committee any timeline?
Minister.
Madam President, I believe that one must understand the volume and the breadth of work required by this committee. It means conducting a number of different surveys in Trinidad and Tobago, and in that context, the chairman of the committee is aware, very, very much aware of the relative urgency of this matter, but I am not in a position to deliver the desired response which the senator seeks. Again, I said, I will await the chairman of the committee to submit a work plan. I have no doubt that would emerge from the second meeting of the board.
Senator Ma.
Madam President, can the Honourable Minister share with this Honourable Senate the names of the remaining members of the National Productivity Council? She did tell us that the chairman is a member of the university. Would she be kind enough, through you, Madam President, would the Honourable Minister, that is, be kind enough to provide the Senate the names of the other members?
Senator Mark, that question is not allowed.
Okay.
You have any further question? Senator Obika, next question.
Thank you, Madam President. Question number 82 to the Minister of Foreign and CARICOM Affairs.
Minister of Foreign and CARICOM Affairs.
Madam President, a joint commission comprising representatives of the Government of the Republic of Trinidad and Tobago and the Government of the Republic of Ghana is provided for in the Agreement on Economic, Scientific, and Technical Cooperation between the Government of the Republic of Trinidad and Tobago and the Government of the Republic of Ghana. It was concluded on the 6th of August, 1997. Trinidad and Tobago completed its process of notification such that all legal requirements for its entry into force have been fulfilled. The Joint Commission will be constituted and convened subsequent to the entry in force of the agreement. Thank you.
Speaker.
Madam President, given that a Joint Commission has a reciprocal element, can the Honourable Minister indicate when would that second part be fulfilled? As he indicated, it will be fulfilled, but can he give a timeline?
Minister.
The second part, I'm not clear, the second part that corresponds to the other party, that is the question that is being asked.
Senator Wika.
For the absence of doubt, if the Joint Commission was held in Trinidad, there will be a requirement for us to have one in Ghana, if that provides clarity.
Minister.
Perhaps with additional information, while not frontally responding to that. 30 days after the notification by both parties through diplomatic channels that all the legal requirements have been met, the agreement, the joint agreement would enter into force. Thank you very much.
Senator Wika.
Madam President, I want to say that I'm totally disappointed with the response, but can the Honourable Minister indicate if a bilateral air services agreement, which normally follows from a joint commission, is in the offing with Ghana?
Minister.
I think we are going around in some circles, but I would provide even more relevant information, Madam President. We are in the process of completing the agreement between both countries and the air services agreement. We expect that to be completed within this month. Thank you very much.
Senator Obika.
I thank the Honourable Minister for the clarity in that response. Can the Honourable Minister indicate whether or not there will be an opportunity to liaise with our counterparts in Barbados, given their desire to have direct flights from the continent of Africa to Barbados?
Senator Obika, that question does not arise. Next question, Senator Obika.
Number 83 to the Minister of Trade and Industry.
Minister of Trade and Industry.
Thank you very much. Madam President, the construction of the ETEC Muruga Agro-Processing and Light Industrial Park is 98% complete, with full completion scheduled for the end of March 2020. The following activities are already completed: all factory shells, roads and drainage infrastructure, utilities services such as potable water supply, wastewater collection, electrical infrastructure, street lighting, security fencing, and culvert works. In addition, the following statutory approvals have been obtained: Certificate of Environmental Clearance for the overall works, approval from the Town and Country Planning Division for development of infrastructure on the site and subdivision of the parcel of land into lots, final TCPD approval for the overall development and subdivision of land and factory shell buildings, design approval from WASA for the wastewater treatment plant, approval from the County Medical Office of Health. Finally, the marketing and tenanting of the park are being done by InvestTT in collaboration with ETEC, the Ministry of Agriculture, Lands and Fisheries, and the National Agriculture Marketing and Development Corporation, NAMDEFCO. The prospectus for the park was completed in December 2019, and a marketing team has already secured interest from 5 prospective tenants, and discussions continue with these potential investors, while promotion and marketing of the park continues. Thank you.
Senator Obika.
Thank you, Madam President. Can the Honourable Minister indicate, given the failure to operationalize the tech park in Point Fortin, what are the possibilities of operationalizing the tech park in Moruga?
Senator Obika, I won't allow that question. Next question, Senator Obika.
Can the Honourable Minister indicate when would the park be operationalized, beyond being tenanted actually, where jobs will be created by tenants of the
Minister.
Jobs have already been created in the construction of the park, and of course, full operationalized or partial, as soon as the park is tenanted, I'm certain that jobs will be created.
Senator Obika.
And given the Minister's last response, can the Minister give us a timeline to operationalization of the park in terms of?
Minister.
As I said, there will be full completion of the park by March 2020. We are in discussions with prospective tenants, and as soon as these come on board, then we would be facilitating.
Senator Obika.
And then can the Honourable Minister give any comfort to persons in Moruga? Because in Point Fortin there is
Are you
nothing
asking
happening.
a question, Senator Obika?
I'm just submitting that there's nothing happening in Point, so that nothing can happen in Moruga.
Senator Obika, a submission is not a question. Do you have a question? Okay, next question, Senator Obika.
Question number 84 to the Minister of Labour and Small Enterprise Development.
Minister of Labour and Small Enterprise Development.
Thank you very much, Madam President. Madam President, the sanctioned strength of inspectors at the Occupational Safety and Health Agency is 48. The actual strength of inspectors at OSH Agency as at January 9, 2020 is 38. The health and safety of workers is of highest priority to the government of the Republic of Trinidad and Tobago. In this regard, the Ministry of Labour and Small Enterprise Development is committed to ongoing collaboration with the OSH Authority in order to continue to strengthen the OSH Agency to fill all vacant positions and improve its function in the implementation and enforcement of the OSH Act for the benefit of all workers. Thank you, Madam President.
Senator Obika.
Thank you, Madam President. Can the Honourable Minister indicate what are the reasons why the OSH agency is operating under its sanction strength?
Minister.
Madam President, it is indeed rather strange that such a question would emanate from the bench of the opposition. Because as I recall, when I became Minister of Labour in September of 2015, I found a situation at the OSH Authority where these very inspectors were operating from home. What does that mean? They were not reporting for duty for over 2 years. There were few positions filled in the OSH agency. So from 2015 to now, we have come a very long way, Madam President. The strength of the organization is 48. We are at 38 and intend to fill the remaining 10 vacancies. Thank you.
Senator Obika.
Given the Minister's failure to have it at full sanction strength, can the Minister indicate when will can the Honourable Minister indicate when the OSH agency is expected to be at its full sanction strength?
Isn't that a repeat of the question you just asked? So next question, Senator Obika.
Can the Honourable Minister indicate confidence in only 38 officers for the entire Trinidad and Tobago?
That question is not allowed.
Can the Honourable Minister indicate apart from referring to a past minister, what is the reason for failure in the OSH agency?
That question is also not allowed.
Public business, government business, bill second reading.
Attorney General.
Thank you, Madam President. Madam President, I beg to move that an act to amend the Interception of Communications Act, Chapter 1508, be now read a second time. Madam President, there comes a time when one can certainly separate general work of legislative growth and aim and intention from very specific and critical work. Under the Constitution, we certainly make laws for the peace, order, and good governance of our society. That implies a general sort of purport, and we see it in the work that we do, usually from day to day, in some of the reforming work that we want to do in a large-scale change society sort of measure. Today's bill, Madam President, is perhaps one of the most critically important bills that we will ever do in our Parliament. Why? We are and have been in this country for decades fighting the scourge of crime. We as parliamentarians are permitted the privilege to make the laws for the peace, order, and good governance of our society. Certainly in December 2010, we saw the introduction of the Interception of Communications Act. That law was introduced, passed on the 3rd of December 2010, assented to on the 17th of December 2010, amended on December 20th, mere days later, 2010. And that particular piece of law introduced into Trinidad and Tobago the offense of intercepting communication. And permit me to explain that. Communication, as defined in the Parent Act, includes all forms of communication: verbal communication, human interaction, messaging, etc. What is an offense at law, pursuant to Section 6 of the Interception of Communication Act, is the interception of communication. Interception is defined as any communication passing over a public or a private telecommunications network. In other words then, the law is confined to an offense for communication being intercepted only on a telecommunications network. There is no offense decided at law in the manner in which telecommunications interceptions are for tape recording, for other things like that, bugging, listening to, etc. It may be breaches that are actionable in the civil realm, depending upon the circumstances, but the criminal law is very specific. Now, of course, this law as proposed today is a 3/5 majority law. We are required to pass this law pursuant to Section 13 of the Constitution because we infringe on certain enshrined rights in Sections 4 and 5 of the Constitution. We are touching and concerning the right to private life. We are touching and concerning the rights involved against self-incrimination. We are touching and concerning the rights involved under a fair trial and due process. The law as it stands now is 10 years old, nearly. It's 9 years old odd. December 2010, we're now in 2020, we're just short of a full 10-year period. What we have in Trinidad and Tobago is now an historical tale which the law enforcement agencies can tell, in particular as a result of litigation and prosecutions which have come about in the application of the law. The representation before us today, the bill before us today, is intended to improve the constitutionality of the law before us. Secondly, to ensure that the law continues to develop. Thirdly, it is a significant introduction of heavy anti-crime measures, and in particular, I am speaking about the introduction of intercepted communication and listening devices in prisons as so defined under the bill, where this law contemplates having non-warranted communications admissible in a court of law in very careful circumstances. This bill proposes the introduction of what the UK law has determined to be fair and proportionate safeguards into the body of our law, not just in the common law of the United Kingdom. This law proposes the introduction of a special procedure by the use of a special advocate to represent the rights of an accused, where we are treating with sensitive personal information which can disclose law enforcement activities. This bill proposes to deliver a tying remedy to a number of other laws which we have amended. Number one, the Strategic Services Agency Act, which was born in 1995 by Act of Parliament number 24 of 1995, that's Chapter 1506. Number two, it ties in the very regulations to the SSA legislation which were introduced into the Senate today, laid on the order paper pursuant to items 10 and 11, published on the 31st of January 2020 by legal notices 38 and 39. Number three, it ties into the law which we just recently amended, which is the Miscellaneous Provisions Law Enforcement Officers Bill. It is Act number 25 of 2019. Honorable members will recall that we amended the Prisons Act specifically to introduce prohibited articles, meaning electronic devices, telephones, etc. We introduced very severe penalties for prisons officers who brought material in, for persons who brought prohibited articles in. We have introduced as well, in another place, yet before that house, another measure of special procedures, and that is to be contained in the gaming law, which is before the house now. So today we are tying up a number of pieces of law by a critical amendment that goes to the heart of attacking criminality, and more specifically, introducing constitutional protection to the persons who stand accused before the courts and against whom interception of communication evidence stands. With that said, I wish to state immediately, members will note the Minister of National Security is here. The time does not permit me to give the underlay and the underwriting of the statistical position of Trinidad and Tobago in the concept of interception and crime, and therefore as the piloter of this motion, and for the purposes of the rule in pepper and heart, as the mover of this motion, I am specifically tying my contribution to that to be given by the Minister of National Security as it relates to the state of Trinidad and Tobago from a Section 13 of the Constitution perspective in the event that there is a challenge to this law. It's not good enough that law is passed with a Section 13 3/5 majority. It must be just in a society such as Trinidad and Tobago, which looks, feels, and is like Trinidad and Tobago, and the Minister of National Security will put that evidence on the record as it relates to gangs, as it relates to gangs in prison, as it relates to the number of interceptions, as it relates to murder, which is committed in Trinidad and Tobago as a result of prisoners using telephones and calling assassination plots and actual assassinations against citizens in Trinidad and Tobago, even as recently as this morning in Trinidad and Tobago. Let me repeat that. In the prisons of Trinidad and Tobago, assassination calls are made from the prison in circumstances where national security, pursuant to Section 6(2)(b) of the Interception of Communication Act, where national security forces, the SSA, the Commissioner of Police, have actionable information that phones are being used in the prisons, assassinations are carried out at the behest of prisoners, and you can do nothing about it because you do not have the privilege of using that as warranted evidence in a court of law, because you have intercepted it in circumstances where the evidence is not admissible in law. I think you understand why I said this is one of the most pointed, significant laws in this country. Let me start by indicating, in the course of consultation, the Director of Public Prosecutions, the Prison Service of Trinidad and Tobago, the Trinidad and Tobago Defense Force, Special Queen's Counsel to the DPP, Mr. Edward Jenkins, QC, the Ministry of National Security, the Judiciary of Trinidad and Tobago, the SSA itself, the Trinidad and Tobago Police Service, the Law Reform Commission, all gave active feedback. The Law Association of Trinidad and Tobago was written to on many occasions. We have received no comments coming from them, and we have been at this work product for over 1 year in preparation. The information coming from the DPP in particular is of significant worth. The DPP, in reflecting upon prosecutorial standing in improvements to the law, recommended certain improvements to the law which stand now contained in the bill before us. And I think importantly, the prisons themselves expressed the view that this particular bill, and I quote here from a letter to me, 3rd of October 2019, where they say, the importance of this bill cannot be understated as a critical tool in the fight against rising criminality in our nation today. Madam President, permit me to go immediately to the bill. The bill is 26 clauses long. As I've indicated, it certainly does traverse Section 4 and Section 5 rights. And the bill has some very important provisions. Now, the government proposes to discuss this legislation over the course of not just today, but at least on another day. We welcome the suggestions coming from honourable members opposite and certainly on the independent bench. I noted the commentary coming from the Leader of the Opposition that they will not support this legislation, and certain concerns were given in a press conference. I do hope that position is not the position of the opposition today, after I have had the chance to pilot this law. Madam President, Clause 4 of the bill in particular starts off with a critical improvement. Clause 4 says that this act shall apply to all criminal proceedings, proceedings under the Proceeds of Crime Act, proceedings under the Extradition, Commonwealth and Foreign Territories Act, proceedings under the Anti-Terrorism Act, and proceedings under the Civil Asset Recovery, Management and Unexplained Wealth Order Act. And specifically, that unless the trial has started, only in those circumstances will it not apply, but unless the trial has commenced and is in progress on the coming into force of this act, for the avoidance of doubt, a trial is deemed to have commenced after evidence has begun to have been led. So long as evidence has not commenced and been led, this act will apply. It is not retroactive. There is a general rule that retroactivity is not offensive and in fact applies only, even though not expressly stated, in the circumstance where it is procedural in nature. If there's a substantive issue, it is deemed to be non-retroactive, and Clause 4 sets this out very carefully, Madam President. Clause 5, Madam President, treats immediately with anchoring what we want to do in this law. What do we want to do in this law? The law spoke to interception of communications. That must be on a telecoms network. It was not broadly worked. It was not specific enough to treat with two very important things: stored data, communications data, and traffic data. Stored data is effectively actual communications that passed over telecommunications network, like text messages, etc., and that will be found at a telecommunications provider. It's stored. It happened within the context of the Act, communication over a telecoms network, whether public or private, and it's stored and accessible. Number 2, traffic data or communications data. This is what we call triangulation data. When a call was made, when it ended, when a SIM card was changed, when the phone was switched off, at what GPS position the phone was when the call was made. This helps to locate the offender, the communication, and the geography of the crime at the same point in time. It's extremely useful in kidnapping cases, for instance, and therefore everywhere else around the world, movies that you look at, where you look at triangulation, and it's axiomatic on the world stage, in Trinidad and Tobago, there's need to insert it in this law, and we introduce the concept today. Madam President, we deal with the definition of a device. Specifically, we have borrowed the broad definition of a device. It is non-technologically specific to include top provisions, voice over internet features used in devices that are not telephones per se, because communications are now done in a multiverse of methodologies, and it is inappropriate to define it as simply wiretapping a telephone or bugging a telephone. You have to contemplate the improvements in technology. We've included an electronic location, because your IP address, your email address, the certainty of person is required to be reduced right down to the electronic location. Madam President, we have also included the definition of a prison, and you will note that we have sought to capture every aspect of prisons, including prisons, quote unquote, under the state of emergency declarations under the Constitution. This harmonizes with Act number 25 of 2019, which is the Miscellaneous Provisions Law Enforcement Officers Act, where we took an holistic definition of prisons. Madam President, we have also sought to include a definition of a rehabilitation center, so we can tuck it into the prisons. Stored communications is specifically defined, as I mentioned earlier. Stored data is specifically defined. A telecommunications service provider, and traffic data, all with specific terms. Madam President, we have also looked at the broader definition of what computer files and programs and access look like. Now, Madam President, let's get to Section 6 of the Act, which is amended by Clause 6. Number one, we were in the old Act only treating with summary offenses. Summary offenses have a prescriptive time frame of 6 months. Generally speaking, if you miss the 6 months marker, there's no offense. We have sought to cleave that offense, keeping summary, adding in a triable either way, introducing an indictable offense, because we have added very significant provisions to the law, and it is appropriate to treat them both summarily and indictably by way of division. Madam President, we then go to a very important amendment. In Clause 6, in amending Section 6.2, I ask honorable senators to take note. Section 6 of the Act, as it relates to Section 17 of the Act, as it relates to Section 17A of the Act, as it relates to Section 18, Section 19 of the Act, those measures, including Section 20 of the Act, that form the, if I can call it, the heart and soul, those form the heart and soul of concerns that honorable senators may have in relation to the general applicability of this law. Madam President, what time is full time for me so I can gauge myself?
You finish at 3:09.
Much obliged. Madam President, that's certainly not enough time to do justice to this bill. Madam President, Section 6.2, as amended by Clause 6, says effectively that we're introducing the fact that you can have warranted intercept, non-warranted intercept. We have that, and we're now broadening the non-warranted intercept to include that you can have a non-warranted intercept for an offense under the Act. That was not there before. Secondly, we are introducing specifically that the non-warranted intercept information can potentially be used in a court of law as evidence, provided that you satisfy a judge pursuant to Section 17.2b and 17.2c that it is appropriate for that non-warranted information to stand as evidence where the safeguards set out in 2b, 17.2b, and 2c are met. Those, for persons who know the law, outside and inside, are the Bailey principles as they have been borrowed from the United Kingdom. We have specifically traversed the laws of New Zealand, Canada, the United Kingdom, Australia, the United States of America, and in those 5 jurisdictions, we have borrowed from the ability to use non-warranted intercept material as evidence subject to the fairness of a trial where a trial judge, as the sole arbiter of the admissibility of the evidence, says whether it can go in or not. Madam President, it is in this clause that we introduce the concept of having interception of every single phone in a prison. Every single phone in a prison vehicle. Unless there is the exception applied for legal professional privilege, which is sanctimonious in law. We preserve the principle that if you are talking to your attorney at law in a privileged circumstance, in the area or phone line designated for LPP, legal professional privilege, that material cannot be intercepted. But in any event, Section 17(2)(b) and 2(c) provide in relation to whether that happened on the phone, that it would be inadmissible because it is LPP, it is legal professional privilege. These are very critical safeguards that are expressly set out in the law. Madam President, in Clause 7 of the bill, we introduce a new 6A. In 6A, we are providing actual notice that you are being intercepted in a prison, that you run the risk of being intercepted. That is again in compliance with the case law that has come out of the European Court of Human Rights, from the United Kingdom in particular, Canada, etc., the Commonwealth jurisdictions. We are taking a step beyond what is normally done, and we are providing notice. Now, Madam President, stick a pin for a moment. The law tells us very carefully, and you look to California, you look to the United Kingdom, etc. The law is, quite simply put, absolutely clear that you do not enjoy the same privileges when you are incarcerated as the average citizen. Yes, there are certain limited privileges, but they can be interrupted provided that the interruption is for penological purposes, i.e. national security, general security purposes. I'm summarizing this. I intend in great detail in my winding up to focus upon the constitutionality by reference to case law and the Commonwealth and other jurisdictions where this is trite law for them that these purposes actually happen. Madam President, I turn now to the introduction of a new Clause 6B. Again, this is Clause 7, a new Section 6B, where we put communications in a prison or a prison vehicle, etc. And Madam President, if we turn now to Clause 9, where we amend Section 8, it is here that we broaden more than just the interception on a telecoms network. We are adding in a new subclause B and subclause C, and there are three of them in the alternative. You can obtain a warrant for interception on a telecoms network for communications. Now we are expressly adding that you can have the ability to obtain by warrant stored communications and also stored data. This is to specifically allow to be anchored in this law something which already exists in other laws. We use the Proceeds of Crime Act, sections 32 to 34. We use the Preliminary Inquiries Indictable Proceedings Act, section 5, to obtain stored data by way of warrant from a magistrate. These things are the standing law. What we are doing is we're harmonizing the ability to do this in the specific law. It may very well be that in the applicability of the law clause 4, that we need to specifically save what has already been purchased by existing law, the interception of communication stored data, material which comes from preliminary inquiry section 5 warrants and proceeds of crime warrants, because that is valid law, and I want to make it clear, we are not under any circumstances repealing that law. This law is not to be deemed to be an implied repeal of that law, and it is specifically saved. And I say so for the benefit of Hansard now and the rule of pepper and heart. Madam Speaker, Madam President, we also add for the purposes that this law can apply to legal enforcement, mutual legal assistance in other territories. Why? We extradite criminals, and it is obscene to not allow the intercept communication to also be the subject of proceedings in another jurisdiction, provided it meets the treaty obligations and the provisions of the Mutual Assistance in Criminal Matters Act, Madam President. Madam President, we turn now to Clause 10. Clause 10 specifically amends a very important, looks minor. Here is where you approach the telecommunications service provider and an obstacle was being created to the tune of millions of dollars at times, where the service provider will tell you, well, if you want to intercept, you pay for it. And then you have to buy the hardware, buy the software, run the risk of damaging their systems. So we reverse the burden like every other jurisdiction does, and we tell the telecom provider, you bear the cost, and that way there's no risk or damage to their system, and they can manage and mitigate their obligations under the telecoms license as it relates to national security. That's a bona fide purpose within existing parameters. Madam President, we turn to Clause 11. Clause 11 allows a judge to extend in circumstances of urgency. And Madam Speaker, I specifically put here the three categories: communications over a telecoms network, stored data, or communications and traffic data, to make it abundantly clear that we're catching all three mechanisms. Madam President, Clause 12 treats with an entity again providing the cost, bearing the cost of assistance. Section 15 is amended, specifically, Madam President, by Clause 13. And again, I'm pointing out the reference to any other written law, specifically so that we are not impliedly repealing the ability to obtain warrants under the Proceeds of Crime Act and also under the Preliminary Inquiries 3 iterations, whether it is the Administration of Justice Preliminary Inquiries Act number 1, number 2, number 3, or it is the Preliminary Inquiries Act Chapter 1207. Whether we're looking at those, we are preserving all. Madam President, Clause 14 ties in again to amendment to Section 16, where we are obliging the maintenance of the key by the telecoms provider or the experts there. Let's get to the heart of Section 17 as amended by Clause 15. And if I could recommend we put a clock somewhere in this direction as opposed to behind me, Madam President, I'd be grateful. Madam President, it is critically important to recognize that in Section 17 of the Act, there was a prohibition against disclosing sensitive information. What is sensitive information? Anything that relates to who intercepted you and discloses their identity, etc. There's a risk to law enforcement if the criminal enterprise knows the identity of persons who work in the series. This is standard around the world. It was passed in 2010 that you cannot obtain sensitive information. What we do here, Madam President, is critically important to improve the constitutionality of Section 17. It is arguable that the 2010 Act can trip the rule of hearsay, that unless you are permitted to cross-examine on who made it, at what time, in what circumstances, and whether the thing was working in proper integrity, that you could stand in a position where you could not admit the evidence. In those circumstances, we are opening the door in very critical ways as follows. Number one, we put the general exception that you can't reveal the sensitive information. Number two, we say specifically that you can, in fact, admit that information if a judge is satisfied that it should be admitted. That is, it is effectively in the interest of justice that that matter be interrogated. Specifically, we are saying that communication, the content of communication obtained Section 6.2, C, D, E, F, and G shall be admissible. Why? Those are the circumstances in the existing law that say that you effectively have consent in those circumstances. When we get to the 6.2b, that is national security, unwarranted. When we get to the 6.2h, that is prisons and prisons vehicles, you are specifically required to also factor Section 6b, the prisons. And here we're saying it shall be admissible in evidence in any proceedings where the judge is satisfied that it would be in the interest of justice to so admit. The case law coming from Europe, coming from the United States, says that you are safe if you allow the separation of powers principle to prevail. A judge can consider the admissibility of the evidence. We therefore want to put constitutionality into this law by improving this section. Here we add the subsection 2C, and we set out the parameters where a judge, in making a decision whether to admit the evidence under subsection 2A and 2B, the judge shall consider all the circumstances concerning obtaining communication, etc., etc., whether the defendant was induced to say what he did, and any other relevant factors which would render what he said unreliable, and shall consider in respect of communications items A through E, which are referred to as the Bailey principles. That's the case of R.V. Bailey. In the case of R.V. Bailey and Smith, 97 Criminal Appeal R. 365 Court of Appeal, the United Kingdom, set out very specific provisions which are recanted here. Nothing done to induce or trick. Integrity of the recording is sound. We have to add interception. The use of recording, we have to add interception device, was proportionate to the gravity of the alleged or suspected offense. The use of the method was appropriately authorized. No recording of legal professional privilege took place. These have been upheld by the courts of law in the Commonwealth, by the highest courts, as being the markers of fair trial proportionality, and we have brought them into this law. So we are removing the complete ouster of evidence. We're solving the potential inadmissibility of hearsay evidence. We are putting in the proportionality principles for the Bailey principles. Madam Speaker, if you look to subsection 4 of section 17, as amended by this clause, we will look to now a very important amendment. In the new subclause B, the court shall not grant leave in relation to any evidence or question referred to in A. That's where you're asking for identity to be revealed, etc., of sensitive information. You must have the express leave of the court. We are saying here that the court must be satisfied by the party challenging the evidence that it would be relevant to the validity and lawfulness of the warrant, the accuracy and integrity of the intercepted communication, the accuracy and integrity of the communication data. Madam President, we're saying that it must also be that the refusal to get that information would render unsafe a conclusion of the jury or the court, as we have judge only now, as the case may be in the relevant issue in the case. And Madam President, in the new subclause C and D, that's where we treat with the exceptions to hearsay. Because we are no longer saying it treats to the admissibility, we're treating to the sufficiency of evidence. Remember that we are very carefully putting judicial discretion as to admissibility. Madam Speaker, Madam President, the court must give leave for the sensitive information and documents concerning the granting of the warrant or the communication itself to be led into evidence, how, when, and by whom, etc. Madam Speaker, Madam President, section clause 16, which amends further the act by the introduction of a new section 17A, is another critical amendment. We are introducing the concept of a special measure via a special advocate. The special advocate is defined. The special advocate is the person who will represent the accused. It will not be the accused attorney at law. It will be a judge selected by the court, a vetted attorney selected by the court. That attorney is permitted to take instructions. That attorney then represents the rights of the accused to ensure that in the event that the material is to be led by way of application, if it is refused, that the material is not unwittingly transferred to where you didn't want it to go, subject to judicial discretion. Obviously, there's no procedural appeal in criminal matters. This is a ground that can be taken on substantive appeal, and therefore you have the right of appeal in relation to these matters. Madam Speaker, Madam President, forgive me, We then go to the provisions of the further sections. Clause 17 amends the provider provisions in subclause 2 of section 18 of the Act. We're tidying up. We lifted the first part of it into the preliminary aspects of the bill, and we're tidying up again that whole concept of telecommunication service. Why? We want to capture both local area networks and wide area networks within the definition of telecom providers as the Act does. We need to now sort this out to make sure the law can actually work in terms of prosecutions. Madam Speaker, Madam President, if we go to clause 18 where we amend section 19, again we are making it pellucidly clear that we can also have communication data, stored communications. In section 19, that's a whole species that treats not just with communication, it treats now with the stored data, stored communication. There may be sensitive information available there. We subject it to the application to the judge. We subject it to the special advocate and the special procedure. We allow for the principles of the fairness of a trial to prevail. Madam President, we also, in both the amendments to section 17, the new 17A, etc., and in the amendments to section 19, we're preserving the rules as it relates to section 14 of the Evidence Act, trade and business documents, and section 14B. Members will recall that we sought to repeal section 14B of the Evidence Act. That is not in effect right now. In fact, we have elected in the Evidence Special Select Committee to do a more wholesome reference to the rules as it relates to computer evidence there, so we will not be proclaiming the abolition of section 14B of the Evidence Act as it relates to computer evidence. I just ask members to note that. Madam President, clause 19 amends section 20 of the Act. Now, section 20 is the destruction of communication which has been intercepted. We have very critically today laid in this Parliament the SSA regs. The SSA regs borrow the provisions of general purpose and employee. It is there that standard operating procedures and special provisions are put for destruction of data. I ask members to note that since 1995, it's the first time regulations have been produced. It is pursuant to an undertaking I gave as Attorney General to this particular Senate. Madam President, critically in section 20 of the Act, by this clause 19, we seek to add new subsection 9. Information which may reveal the commission of other offenses by other people or which may jeopardize other inquiries shall not be disclosed to the accused, but shall be retained and be the subject of a public interest immunity application to the court by the prosecution. This is landmark reformation of the law. Without this provision, if you were to obtain the sensitive personal information, if you were to obtain the disclosure which we're now putting in, you may unwittingly reveal and tip off persons against whom there are investigations afoot. And very importantly, in the United Kingdom and in the rest of the Commonwealth, the prosecutor has the right to say, you can't get that evidence by exercising the public interest immunity argument. It's an application where the prosecutor asks the court to exclude that evidence. Remember, it's not automatically excluded. It must be the subject of a court granting the exclusions. And again, this is effectively trite law in other aspects in other parts of the Commonwealth, Madam President. Madam President, in clause 20, we amend section 21. We're adding in or another officer authorized pursuant to section 5.2 because there may be experts involved in the use of a telecoms provider and they have to get into the integration of systems and disclosure. Madam Speaker, Madam President, we're adding in, very importantly, a new section 23A via clause 22. Here we add the tipping off provision. Tipping off is a reality in this country. It has to be criminalized. We criminalized it very heavily in the Miscellaneous Provisions Law Enforcement Act, which is Act number 25 of 2019. We did that in December of last year. We are putting it into the Interception of Communication Act because we are aware that members
Attorney
of the
General,
protective services...
You have 5 more minutes.
We are aware that members of the protective services unfortunately find themselves in the engaging of tipping off. I can give an alert right now. We are drafting a law. We are nearly finished with it. We're on final review to put in mandatory provisions for lie detection across the services. Let me repeat that. Mandatory provisions for lie detection across certain aspects of national security. Very carefully crafted. Obviously, the consultation on that has to happen right now, and it is imminent. Madam President, we have also sought in Clause 23, importantly, to add the fact that regulations should be accepted from Section 63 of the Interpretation Act. If you breach a regulation and you don't put the exemption to Section 63 of the Interpretation Act, you are subjected to a whopping $500 TT as the fine. We have now added in a fine of not exceeding, effectively, because that's the maximum, of $250,000 and imprisonment for 2 years, because this is serious business. Importantly, Madam President, we had not had the rules of the Supreme Court tied into this. We have introduced via Clause 24 a new Section 25A to allow the Rules Committee to introduce rules that can run alongside this as we move into the operationalization of the criminal division. Madam President, as all of these pieces come together, as we move to opening 125 new courts in this country for the first time in the history of this country, as we tie in the improvements to processes, the quickening of laws, be it plea bargaining, trial by jury, criminal proceedings rules, removal of motor vehicle and road traffic offenses, removal of preliminary inquiries, removal of decriminalized matters, for instance, ganja cases, as we get less and less matters in more and more specialist courts with more judges, with masters of court, under a rules-based environment, it is critical that we preserve the integrity of prosecutions which are going to come into the system faster. So, Madam President, I ask honorable senators today to draw a line in the sand, to say that a prison should be a prison, to say that it is unacceptable for assassinations to be called from inside the walls of a prison, to say that the courts ought to have the benefit of that information put before it for consideration as it relates to admissibility, to protect the identity of law enforcement officers, to use special advocates, to preserve the domain of legal professional privilege, to accept what is now plain, logical, and axiomatic in other jurisdictions, i.e. all of what is contained in this law, because it exists in the rest of the Commonwealth. I ask honorable members to reject what I heard in the public domain coming from the Leader of the Opposition. I ask honorable members to drape themselves in the national flag of Trinidad and Tobago today, red, white, and black only in a national color, so that we can right the scales of justice in Trinidad and Tobago. The floor is open. Commentary will be received. We at the government end are listening intently to improvements that can be made on this bench from all sides, including the opposition. I ask for your patriotism today, and I beg to move.
Honourable Senators, I shall now propose the question for debate. The question is that a bill entitled An Act to Amend the Interception of Communications Act, Chapter 1508, be now read a second time. Senator Sobers.
Thank you, Madam President, for recognizing me. Madam President, the bill before us this afternoon, I agree, is extremely important. I myself, when I first heard of this particular act that would have been passed in 2011, relished the opportunity to one day to treat with it because I had some concerns. What the public must be aware or needs to be made aware of is that we are basically talking about tapping phone lines, tapping internet communications, tapping into private scenarios. Yes, for the benefit of justice in some instances. Yes, to preserve the work being done by our national security service men and women. But there must be a balance. This particular piece of legislation, these series of amendments, for the better part of what I would have understood them to be, especially looking at the bill essentials, when we talk about comparative legislation as articulated here, seems to come directly from the UK experience. I would have listened to the Honourable Attorney General indicate that he considered, or the team considered, legislation throughout the Commonwealth and to other parts of Europe. The difficulty, however, in terms of my reading and understanding, the majority of this bill comes from the UK experience. And in terms of my reading from other pieces of legislation throughout the world, with respect to the US, South Africa, Israel, Canada, many of those jurisdictions set themselves apart. As a matter of fact, many of them have poured proper scorn on what obtains in the UK. The UK's position, which I believe this bill is mirrored very closely upon, comes from the Regulation of Investigatory Powers Act 2000. And in terms of my reading, by an article entitled The Justice Project, Legal Opinion and Intercept Communication, the writer indicates that RIPA, which is the Regulation of Investigatory Powers Act 2000, RIPA creates asymmetrics. The defendant is the one party with most to lose here. The defendant is never allowed to examine the content of intercept communications. The normal duties of disclosure by prosecutors do not apply in RIPA, leaving the defendant at a loss of means of defense. Now, I appreciate at certain parts of the bill, it allows for some degree of disclosure. I appreciate respectfully that in terms of what obtained in the current parent legislation, there is currently, in terms of this new amendment, a widening of the ability to cross-examine in certain circumstances. I appreciate that. But still, more needs to be done. And if we were adopting that position today to better the legislation that is currently on the books, I would advance that we have in fact fallen a bit short. I expect the Minister, the Honourable Minister of National Security, to indicate the position we are in statistically with crime and criminality within this country. I am very well aware. In my contribution in the Miscellaneous Provisions Bill last year, I indicated emphatically how I view transmissions coming from the prisons, and that something needs to be done to stamp that out. Last week when we were here dealing with the crime debate as well too, I indicated that it upset me greatly to be aware that a particular communication would have come from the prisons with respect to a hit for someone that I was personally familiar with. So I appreciate those particular circumstances. But it is in times like these where we figure our backs are properly against a brick wall that we must dig deep to ensure that we do not trample upon the rights of citizens who've entrusted us here within this Parliament to seek out their best interests. That sometimes when we are placed in these positions, we effortlessly give knee-jerk reactions. And I believe some of what is contained here reflects that position. I think if more sensible consultation was done, because I heard the Honorable Attorney General indicate who he consulted with, or at least where letters would have gone out. And in all of the organizations that were raised by the AG, most of them, I dare say all of them, were state entities. And that the only one that was not a state entity was the Law Association. I admit I hear what the Honorable AG indicated, that the Law Association was, well, at least the documents would have been sent, but no formal communication would have been given. But this is something that affects us all. What about the Criminal Bar Association? Were they consulted? No, but they are separate and apart in terms of what they can offer. And these are the persons that would represent properly the interests of individuals who may very well be defendants before the court. It cannot be that we articulate positions only with respect to the state and not for the persons who pick up, just like members of the TTPS, just like members of the regiment, just like members of the Coast Guard, in defense of the public. These individuals defend public individuals as well too. It is the common man that is going to find himself before the courts in these particular positions. They are going to be the nefarious ones who should find themselves here. But we should have offered a position, or at least an opportunity, to those entities that represent the interests of persons who may very well be innocent, finding themselves in these precarious positions, an opportunity to raise and voice their concerns. Madam President, jumping directly into the bill, I looked at the introduction of stored data and stored communication, which is located at page 5 of the bill. Now, in terms of my reading and understanding of how other jurisdictions treat with stored data, in particular in Canada, and the Honorable AG indicated it himself, when we look at stored data and stored communication, we have legislation on the books that currently treat with that particular form of information. And generally, those aspects of information are subject to search and seizure and not interception. So I found it very strange, and it bewildered me greatly, why are we intercepting or placing before this House an opportunity for us to utilize interception mechanisms for stored data? If we are to be symmetric in terms of what currently obtains with respect to the other pieces of legislation, we could have subjected those things specifically to search and seizure. That is what warrants are available for. So why are we placing stored data and stored communication in the realm of interception? And I would hope either the AG or the Minister of National Security could treat with that as well. Page 8 of the bill also addresses this issue of a designated place. And I have a lot of issues with respect to a designated area. Having practiced in the criminal arena, I am aware, in terms of the many of us who sit in this chamber, would have gone to police stations on many occasions. And there is supposed to be a designated area where an attorney at law would meet with his client, often referred to as the barrister's room or counsel's room. But on many occasions, I would have visited police stations, the Immigration Detention Center, even the prisons on some occasions, and that designated area is not available. And so, we have to accommodate in law enforcement officials and see our clients at secondary locations. Is it now, based upon this bill before us, that those locations will be subject to some type of interception? If the infrastructure is not in place to properly treat with the designated areas that we have currently right now, are we as attorneys subjecting ourselves to have our communication, privileged communication, between attorney and clients breached by this particular bill? Looking on as well too, at page 9, where Section 8 is amended. Section 8 deals with the procuring of the warrant by the authorized officer. And it is here that I expected to see many changes with respect to how these warrants are in fact procured. In terms of reading and understanding what obtains in other jurisdictions, I would have really hoped that the government would have compared the obtaining of the warrant to what obtains in the US. The US is the one place in terms of my reading and my understanding wherein there are several safeguards put in place to protect the public from officers and authorized individuals who may approach a judge for a warrant to intercept communication. Why haven't we considered, in terms of amending this particular part, where we are asking a judge to consider an application for interception, that parts of the communication has to be specifically identified? It must not be then that the entire conversation being had is available for interception. If there's intelligence that is brought before the judge for the warrant to be procured, the officer must be in a position to indicate specifically what they are looking for. And a parameter is set by the judge so that there's no trampling upon other persons' rights in terms of what private conversations that individual is having with other individuals. I would have liked to see specification with respect to an indication as to who is actually being listened to. We're looking at Section 8 AG, I'm hearing you, and that's why I'm dealing with in terms of interception.
Senator Sobers.
Yes.
I
apologize.
May I advise you to just direct your presentation to the chair?
Yes,
okay?
grateful, please. Yes.
Listen to the people.
Yeah.
Ignore the outgoing MP for something else.
So I would have liked to see some specification indicating through the judge as to who exactly is being listened to with respect to this interception warrant. In the US as well too, there's a minimalist requirement which indicates exactly what parts of that communication should be allowed to be intercepted. There's a distinction as well too between public and private communication, which is not really properly articulated here. Another big miss with respect to the application of the warrant, which I would have loved to see here, would have been a time frame. It cannot be then that we are asking a judge, a judicial officer, that we want to tap X or Y's phone or tap X or Y's communication, and it is for an unfettered particular period. There must be some specification. In all the jurisdictions that I have looked at, there is a limit, either 30 days or 60 days in some circumstances. And based upon evidence that is brought thereafter, that particular period can be extended. This is something I would have liked to see here, a parameter set out specifically here to treat with such an issue. There's also a miss with respect to oversight in this particular application as well to under clause 9, amending section 8. In most other jurisdictions, there's a reporting condition. So whilst the individuals, the authorized officers, are listening into the communication, they must report specifically to a senior officer who can indicate whether or not the interception is actually procuring or bearing any fruit. And if it isn't, it would be cancelled. What is also missing here is chain of custody. In most other jurisdictions as well too, there is a chain of custody approach to treating with these issues, where intercepted material is actually properly sealed and placed before a judge, subsequent to it being done. That is also missing here. And it begs the question, if we are really truly amending this legislation for the benefit of the end user, why wasn't all of these things considered before we actually rushed to the Parliament with this particular piece of legislation? I would hate to think that there's some other sinister approach behind the government in bringing this legislation to this Parliament at this particular time. It is It is without a doubt, I mean, we all know that this is an election year. And I'm really wondering whether or not this information or the ability to intercept as being proposed to this Honorable House, is it really intended for the individuals articulated by the government behind prison walls? Or is it going to be an attempt, because there is an inclusion now, an amendment now, wherein persons would be able to intercept information without the use of a warrant. And before, such information would not have been admissible into court. Now it is going to be. Respectfully, it isn't a far-fetched idea or approach or far-fetched fact that under this particular administration, interception was taking place. Many members of civil society, their privacy was breached. Many persons within this chamber as well too.
Senator Sobers, be very careful
Guided,
in how
please.
you're making your presentation. Be aware of the standing orders about imputing improper motives. Okay?
Guided, please, my lady. Madam President. The PNM administration The PNM administration was the one who ran afoul of that particular incident. So we have to be careful, we have to pay attention, lest we find ourselves in that particular position. I also looked at clause 9 as well too of the bill, where they are winding of the provisions for when a judge can actually issue a warrant. Now, at page 10, it indicates that under the Mutual Assistance in Criminal Matters Act, or given effect to the provisions of any international mutual assistance agreement. Now, when one looks at clause 4, located on page 2, it is clear that this act applies to criminal proceedings, proceedings under the Proceeds of Crime Act, proceedings under the Extradition, Commonwealth and Foreign Territories Act, proceedings under the Anti-Terrorism Act, and proceedings under the Civil Asset Recovery and Management and Unexplained Wealth Act, all being acts of Parliament. But now we are allowing for interception of material based upon any international mutual assistance agreement. Any international mutual assistance agreement. All of these treaties that may very well be considered here should be acts of Parliament as opposed to mutual assistance.
Attorney General. Okay. Yeah. Senator Sobers.
Well, if it's troubling, you could leave the chamber. So
I would ask members to please comply with the standing orders. Okay? Senator Sobers.
Madam President, I apologize. Right? So that if we are treating with something as serious as interception of communication, it should be subject to acts of Parliament and not some treaty.
Attorney General, I am so hearing you. Could you please, yes, continue, Senator Sobers.
Yes. I also looked at clause 10, which amends section 9 of the Act. And I heard the Honorable Attorney General indicate that in previous incarnations, when an application would have been made and it would have been granted, and they had to treat with particular entities, the cost would have been enormous for those entities to to put that cost upon the state, to bear that cost in terms of procuring this intercepted information. And now we are switching it so that that burden now falls specifically onto the entity. Now, as much as I think that that is a bit unfair, even if it is we were to consider possibly sharing that burden, maybe half and half with the entity, because you are in fact talking about millions of dollars. When we read further on at page 11, where section 3 is amended, the new subsection 4, it also deals with a person having to bear his or her own costs. And that is extremely troubling. Procuring this particular amount of information, as the AG would have indicated, is going to be extremely expensive. It shouldn't be that the state is the one, having gone through the process to procure this warrant, based upon whatever information that was at their disposal, is now putting this onerous burden upon one person to spend all this money to provide this information to the state. That is something that has to be considered and must be changed entirely. At page 14, criteria is given for how evidence and intercepted material should also be considered by a judge. And it speaks to the proceedings which should be employed for the judge to consider such material. Now, in terms of my reading, I would have come across several situations within the UK and in the US, where, in the US especially, not the UK, in the US and in South Africa, and in Canada as well too, where such material being placed before a judge for his or her consideration, apart from individuals, the actual individuals who would have intercepted the information, there are also persons who can articulate, with respect to probabilities, scientific calculations as well, as to how the intercepted material, especially the voice of an individual, matches possibly the defendant before the court. And in our society, I mean, it is a well-known and settled fact. I mean, up to recently, while reviewing this particular piece of legislation, I recalled that there was a gentleman who mimicked the voices of several members of Parliament. I mean, when I listened to it recently as well, so I mean, you know, the gentleman, he did a good copy of Senator Mark, for example. I don't know if he was, yeah. Right. And he did a good copy of members of the government and whatnot. And I'm just saying, just for instance, and it has come up in cases that I would have read, if there is not someone, as this individual in those matters would have been sound engineers, would have been able to indicate, yes, apart from the methodology employed by the authorized officer to procure this information, that you have a sound engineer coming before the court indicating, based upon scientific calculations, that the voice matches the defendant before the court by 95 or 99% probability, then this information could definitely be challenged. And there are very well many persons who may find themselves in a precarious position before the courts because we do not have, or we have not legislated for some individual of that nature to present evidence before the court as well too. So it's not only going to be based upon how the information or the intercepted material was procured, but we should have someone such as a sound engineer, and I'm just pulling that from other jurisdictions, to indicate emphatically what the position is with respect to a statistical comparison. Further, at E, it allows for the recording of conversations at any time, once not in a designated place designated by the Minister of National Security. Now, I am fully well aware as to the position I articulated in December when we dealt with the miscellaneous provisions bill. I'm fully aware with respect to the position I articulated when we dealt with the crime debate last week. And I can understand the position that, yes, a prison is a prison is a prison, and there should be no cell phones at all within the prison. That prisoners, having been placed there, would have given up certain rights and privileges, and that we must be very careful with how we treat with those rights and privileges that they no longer hold. But there have been positions within us, within Trinidad and Tobago. I mean, practicing in the courts myself, I have been in positions where prisoners would leave the prisons, come down to the courthouse. We would be given a moment to speak with them, to take some instructions. And those places aren't designated places, but there's a certain degree of privacy afforded to us based upon the information that is being procured. There are going to be situations, or I know of situations where prisoners, based upon certain restrictions, would not have been given an opportunity to speak with counsel for whatever reason. And in terms of the communication that is actually being made between a prisoner at the prisons or the restricted facility, as outlined within the definitions before, and his counsel, one has to balance whether or not we are going to wade into those particular waters. Should the conversation between a prisoner, even though it isn't a designated place, and his counsel over a telephone at a prison be subject to intercepted material or intercepted communication? Or should that particular conversation, once it runs into legal privilege between the prisoner and his attorney at law, be protected? Are we at that particular stage in our society that we are willing to say no? Because this is what this particular amendment calls for. This is what this particular amendment calls for. And I have heard the remarks being made, not only by by the government and by commentators outside, that there are criminal lawyers and then there are lawyer criminals. And yes, it is a fact. There are lawyer criminals. But are we willing now, based upon the very serious actions of a few, to do away with privilege that has existed from time immemorial, that has existed to protect information created and allowed to benefit a defendant before the court? Because I have said it time and time again, the state tends to have infinite resources at its disposal to prosecute an individual before the court. It comes from the beginning of situations with respect to the TTPS, go all the way up to the prosecution and the DPP and whatnot. But for that one man or one woman, his or her only defense is his lawyer. Are we at this stage willing to trample on those rights? It is something that we really, really need to wrestle with and consider. I am not of the opinion that we should wade into those particular situations. There's a lot that needs to be done to ensure that this designated area and designated space and designated situation works well before we can even consider a situation like that. Going to clause 16 now, this introduction of closed proceedings and special advocate later on. In a closed proceedings, as articulated in this bill, no accused or defendant would be present while these issues are being treated with. None. The bill is quite clear in terms of excluding an accused person. In other jurisdictions, with respect to disclosure of sensitive information, especially in the US, in Canada, in South Africa, that information is disclosable. The defendant or the accused is before the court while that information is being disclosed. There's no cloak and dagger clandestine approach to doing these things in these countries. And I think that is what we are trying to do here. It could never redound to the benefit of citizens within this country. For example, in South Africa, in Canada, when persons are dealing with information, sensitive information, there's a particular application that is made for that type of disclosure. And it is commonly referred to as breaking of the seal. And what happens is that the prosecution is given an opportunity to edit certain information or have it blocked out to preserve the identity of criminal informants and officers who may very well be currently in the field procuring information. Then the information would be passed on to the defendant or his attorney at law, and further applications can be made if it is that that information is required to properly prepare his or her defense. But to eject the accused from that particular hearing is a total step backwards to how far we have come. And the very concept, I know that Senator Hussain will treat with it properly, the very concept of this special advocate is something that does not exist in all these other mature jurisdictions. I'm so sorry that I have to actually say that in terms of juxtaposing Trinidad and these other jurisdictions. This concept of special advocate does not exist. How can we talk about confidence in a system when you yourself, respectfully, not any member of the government, respectfully, not any member of parliament, finding themselves before a court and having retained an attorney at law who you have confidence in, and then the same justice system is turning around and telling you, well, here, what, for this particular proceedings that concerns you and your future and your liberty and your life, you ain't gonna be in the proceedings. And your lawyer, he coming out of the courtroom too. Have confidence in us, the judiciary. We will find a lawyer for you. What is the criteria that is going to be utilized for this special advocate? Are we aware what experience this individual is going to have? Are we aware that if they are even going to be available? What is the bill that is going to be foot by the state to pay for these special advocates? A special advocate who would only meet his client that very first time to take this set of instructions. That is the position that we are going to be placing citizens in this country. That is extremely irresponsible. I cannot imagine any citizen who would readily or not be in a position like this and have faith and confidence in an institution that is going to articulate and operate in a manner such as what we are proposing in this particular piece of legislation. And we are doing all of this, Madam President, speaking about closed proceedings, speaking about a special advocate, talking about intercepting stored material and stored communication. And we're not hearing about all of the other infrastructural changes and infrastructural problems that this institution is crippled with, that we have asked time and time again for updates on. I think everyone in this chamber and all the listening and viewing public would have slept way more comfortably at night just by simply indicating to the public that, listen, we've done it. Last week, we have the jammers, they came down, we installed them at the prisons, and they are totally working. No more communication. Why the need for something like this at a time like now? Yes, because statistically.
Senator Sobers, you have 5 more minutes.
Grateful, please, Madam President. Yes, statistically, crime is out of control. Prison officers are being gunned down. Police officers are being gunned down. Hits are being called from the prisons on citizens and whatnot. But all of that could have been fixed with a jammer. But no, the government chooses to come here at this 99th hour with this set of legislation that they pull from here, there, and the other, that specifically mirrors the UK position. In their own bill essentials, they compare to the UK position. And I know in terms of the bill essentials, usually from this particular Attorney General, we see in legislation from all throughout the Caribbean and the Commonwealth. To tell us about interception for private information without properly exploring this particular situation as they should have, as a responsible government should have. And this is not any partisan approach. I asked, as I listened to the prayer of the Senate in our deliberations, so that setting aside private interests, unwholesome prejudices, and personal affections, we may treat all matters set before us with honesty, courage, and conviction. And that is why I'm saying emphatically, if this is not removed, proper consultation is done with the stakeholders who are set out there to defend our citizenry, we will not support this. Thank you.
Senator Seepersad.
Madam President, thank you for the opportunity to contribute to the debate on the Interception of Communications Amendment Bill 2020. I'm deeply concerned about the frequency, callousness, and apparent ease with which criminals carry out their cruelty. Last weekend, we watched with horror at the number of serious crimes committed in our country. Today is no different. The fear factor of ordinary citizens cannot be underestimated. I am aware that those who have the wherewithal are prepared to pack their bags and leave Trinidad and Tobago immediately, unless immediate and measurable results are evident. Platitudes, grand charge, and old talk will no longer cut it in this environment where criminals provide the leadership in forgotten communities. These same criminals benefit from the largesse of the government, as clearly stated by no less an authority than the Commissioner of Police himself. So, Madam President, will the inclusion of the changes proposed in the Interception of Communications Amendment Bill in the arsenal of law enforcement for crime fighting add to the efficacy of bringing criminals to justice? This legislation infringes on the constitutional rights of citizens, and therefore pushback from various pressure groups is expected. Clearly, the right of the individual citizen cannot be compromised willy-nilly and must be balanced against interests of national security, public safety and security, the economic and social good of the country. If these interests are conflicting, then the constitutional rights of the individual must be preserved. Given that the primary responsibility of governance is the safety of all citizens, it may become necessary to temporarily rescind individual rights so that law enforcement can have a decided edge in the fight against organized crime, terrorism, or a threat to national security. In this regard, legislation alone will not suffice, and priority must be given to policy, systems, and procedures for addressing this existing long-term social ills, maintaining good order, security of the country, prevention, investigation, detection, and prosecution of crimes. In several countries around the world, the use of intrusive directive surveillance or covert intelligence sources by public entities are regulated by law. Some examples include the Australian Data Retention Law, the UK Investigatory Powers Act, the USA Freedom Information Act, and the USA Communications Assistance for Law Enforcement Act. As recent as January 2020, the Trump administration has bought access to a commercial database that maps the movements of millions of cell phones in America and is using it for immigration and border enforcement. The location data is drawn from ordinary cell phone apps, including those for games, weather, and e-commerce, for which the user has granted permission to log the phone's location. Madam President, the current crime situation in Trinidad and Tobago requires law enforcement officers to have ironclad evidence to convict criminals. We cannot rely on the traditional methods of witness statements and eyewitnesses if we want to capture gang members, human, drug, and gun traffickers, so-called Mr. Big Fish. Madam President, the world of information technology and electronic communication is moving at light speed. Many criminals already have more sophisticated hardware and the requisite software to encrypt, disguise, and deceive electronic surveillance in all forms. The dark web is the preferred electronic network for criminals. Further electronic information, be it video, audio, text, or graphics, can be falsified and protected in many ways. In recent times, Apple refused to assist law enforcement officials in providing access to an electronic device. I believe this legislation is not aimed at petty criminals. I also believe that electronic surveillance and data capture already exist, but require legislation for legal use. I am convinced that fighting crime requires new options, since we cannot keep doing the same things and expect different results. From all appearances, law enforcement is currently on the losing side. Madam President, we cannot expect law enforcement to make progress in fighting crime when they are handicapped by laws which prevent them from retrieving and using intelligence and evidence from all possible sources. Criminals are acutely aware of the existing legal limitations in accessing data from electronic devices and the use of evidence from such devices. Somehow, prisoners can access mobile phones which, it is believed, are used to order criminal activity from the prisons. Law enforcement should be able to monitor, intercept, and record prisoners' communications. They should also be able to seize devices and retrieve stored information for intelligence and evidence purposes. Safeguards to preserve attorney-client privilege is necessary. There should be certain designated areas in prisons where conversations will not be intercepted or recorded. These areas should be the areas that are monitored should be clearly marked. The bill also provides safeguards for the misuse of the powers to intercept and the offenses for persons who act without authority. Madam President, the current legislation provides that the interception of communication can only be done by a judicial warrant applied for by an authorized officer and issued by a judge after taking into consideration all factors. Additionally, there will be judicial oversight and fairness to the accused so that the stipulated factors will be considered before admitting the evidence into the court hearing. Therefore, there are checks and balances in place to ensure that the law is proportionate. I am by no means seeking to diminish the constitutional rights of citizens. At the same time, given the gravity of the crime situation, Madam President, I propose that a limited period be given to gauge the effectiveness of the bill. By this I mean consideration be given to a sunset clause of, say, 2 to 3 years. At the end of the period, an analysis can be done to show the effectiveness of the changes implemented from the time the bill is made law. Factors to be considered include significantly increased detection rates, substantially decreased murder rates, overall decrease in the prevention of crimes. I believe that law enforcement already have set annual targets given the prevailing conditions. These targets must be revised to reflect performance which is due to this bill alone. Given proven statistical improvements, the bill can be brought back to Parliament for extension. I suspect this suggestion can be more properly dealt with in the committee stage. Accountability. The Interception of Communications Act 2020 provides for a system of parliamentary accountability. Because the Act interferes with the individual's rights, the Parliament has a crucial role in the operation and scrutiny of the legislation. Clause 24 of the Act provides that the Minister of National Security prepare an annual report within 3 months after the end of the year in relation to the operation of the Act in the immediately preceding year. A copy of this report is to be laid in both Houses of Parliament. I can only find the Interception of Communication annual reports from 2010, when the law was enacted, to 2016. Madam President, if this is the case, I must request that the reports for 2017 and 2018 be made available to Parliament immediately. The 2019 report should be laid in Parliament in the time frame stipulated by the Act. Thank you, Madam President.
Minister of Security.
Thank you very much, Madam President. Thank you to Senator Seepersad for that very sensible contribution, if I may put it that way. Madam President, I joined this debate here today to talk about a very important tool in the fight against crime. And I sat here and I listened very attentively to Senator Seepersad, and she hit all of the right notes as to why the time has come for us to tackle crime in the manner that we are. So I'd like to start today, Madam President, by talking a little bit and very briefly about the importance of interception in the fight against crime. In national security, and in particular in law enforcement, and more so in dealing with interception and the tools that are designed to deal with what takes place constantly, and all of us in here would use the technology, but rest assured that the criminal element are also using the technology, and they may also be using technology that is in advance of what we do. Because as law-abiding citizens, the vast majority of us anyway, I assume we would have absolutely no difficulty having open communications and calls with each other. None. Absolutely no difficulty with who we talk to and where we talk to people. Let me put at the outset that this bill here today, the significant amendments being proposed, are to deal with persons in prisons. So I find it difficult as a citizen of Trinidad and Tobago, as a law-abiding citizen, and as someone with the current responsibility for national security, to understand how anyone can make a legitimate argument that they should be permitted to communicate with a person incarcerated outside of the means provided in the legal sanctity of a prison. So I want to put on record at the outset that in our prisons, persons are permitted to communicate via specific landlines set up in designated areas with their family members and their lawyers. Their family members and their lawyers are then permitted visitation rights. Outside of that purview, I cannot for the life of me believe that any law-abiding citizen would put forward any conscientious argument that a prisoner has a legitimate claim to use of a cell phone. Cell phones in prisons, tablets in prisons, any device to communicate outside of what the state provides for you in a prison as a prisoner is contraband. It is illegal. And I will get to some examples of what is taking place right now and why this piece of legislation is important. So Senator Seepersad was correct when she talked about proportionality. The time has come. In fact, it is too late in coming. But finally, we've moved on it. And today we're here to debate very important amendments. But let us put them in the context of the existing legislation, because there are the protections and there are the safeguards in the current legislation. So in balancing exercise, Madam President, in national security, you're constantly called upon to balance the protection of the state and its citizens, their safety and security, with the protection of individual persons' privacy. But you see, no prisoner can legitimately argue that they have a right of privacy to utilize contraband, illegal cell phones or other devices for communication. To suggest otherwise is an acceptance by us as citizens that we're living in a state of anarchy, because those prisoners are not calling, using these cell phones to conduct legitimate business. And I cast our minds back to the days prior to cell phones. Prior to cell phones, and not many people will know it, the new generations would have no concept of landlines whatsoever. I have a landline on my desk as Minister of National Security, and if I pick up that phone, or if there are calls on that phone, over 10 since I've held the office of National, I will be in shock. Everything now comes on your cell phone. But cast our minds back to pre-cell phones. Every prisoner would have the right of conversation and communication via landlines. That exists. We have set up, we even have a system in the prisons that are listed here, where your family can put credit on cards so the prisoners don't need money. They go and they type in a code and it gives them access to an outside line. So lest anyone believe that there is not sufficient technology set up, legal technology, for incarcerated persons to communicate with whomsoever they want, their family members, their friends, their lawyers. It exists, it is available, it is not something new. So to try this fear-mongering and to suggest that, oh, you would not have the opportunity, you would not have the availability, and I'll come to the legislation, not true. So in the balancing exercise in national security, you're constantly balancing the individual's right to privacy versus securing all of the citizens, securing the state and providing for their safety. Not an easy task. But we are not the only country that faces the difficulties, nor are we the only country to deal with what we're dealing with today. I want to remind persons as well, Madam President, through you, that in today's world, the prevention of criminal acts includes acts of terrorism. And when anyone who follows international news, and knock on wood, we've been very fortunate in Trinidad, thankfully, due to our law enforcement agencies and our intelligence agencies and our international allies providing us with intelligence so far, every time you hear about an act of terrorism, including the recent acts in Great Britain with stabbings, the last two were persons who had just come out of prison. And you always hear afterwards the intelligence agency saying, well, we were monitoring them, but we crossed the line and felt it wasn't necessary anymore. Don't let us fall into that trap here today. Let us provide what this act, what this bill is seeking to amend the Parent Act on, is to provide us with the opportunity to utilize Intercept for evidential purposes. That cannot be overemphasized, the importance of allowing us now to prosecute anyone who is illegally communicating with prisoners. Why would you want to fall into a protected category of communication there? So it now allows us, and I will get to in a short while, very carefully choosing a few examples to let the population, and in particular the members of this House, know of the types of communications that are taking place, the types of people that are speaking to criminals, and the types of conversations that go to the heart of securing Trinidad and Tobago. Every jurisdiction in the world in national security needs to intercept. Senator Seepersad was talking about some of the most advanced nations, in particular the United States, and the type of intercept that they are doing now. It is a reality. Let us not bury our heads in the sand and pretend it doesn't exist. The balancing exercise is to make sure that it is utilized and there's sufficient safeguards and accountability that is utilized for the fight for good as opposed to being abused. It's needed for monitoring, intelligence gathering, and evidence building. It allows the disruption of criminal activity and, importantly here today, gives law enforcement the ability to prosecute criminals for this criminal activity. And I'd like to put on the record, because I heard it being suggested by a previous speaker, that where is the consultation, where will law enforcement? It is law enforcement that asked for this. So let me put that at the outset. As I've said here repeatedly in the Senate, all we can do as legislators, each and every one of you, is pass law. That's your job. We don't for a moment think that legislation alone is going to solve anything, but it is one of the tools and one of the assets. And these particular amendments that were worked on for a long time by the Attorney General, out of the Attorney General's office, was requested by law enforcement. Because law enforcement and our intelligence services know what they're facing in the fight against crime, and in particular in the prisons. This act provides the necessary safeguards governing lawful intercept. The current act, we must always protect both individuals and national security interests in order to provide that safety and security for Trinidad and Tobago. Madam President, I say here, without fear of contradiction, having gone through these amendments, that these amendments achieve that balance. They allow authorized officers, and I'll get to who are the authorized officers, to do their jobs via intercepting, but also protect the rights of law-abiding citizens. So the original act, the parent act, and I want to just remind the population and senators who is allowed to intercept. There are three authorized officers: the Commissioner of Police, the Chief of Defense Staff, and the Director of the SSA. There is nobody else pursuant to the legislation of Trinidad and Tobago that can legally intercept. Those are the people that we have entrusted to carry out their job and their duty. And there is only one person that they report to: the Minister of National Security. And it is built in here, the protection. So every single time, whether it's a warranted intercept or whether it is an intercept for intelligence, the Minister of National Security, within a number of hours, days at maximum, is provided with a report that an intercept has been started. And I can tell you, as the Minister of National Security, you do not know who is being intercepted, because codes are used, but you're being told it is for breach of these particular laws. So they're intercepting because they're going after gangs, or they're intercepting because they're going after persons who may be suspected of having ISIS links, and that is all you know as the Minister of National Security. But it's an oversight, because I read every single report. And if I find something strange, I will call upon the officers to explain what is this about. But you have someone looking on at it. And if any officer who is authorized to intercept breaches the law, there's sufficient provision in here. So I have had cause to warn people at times and to say, don't get involved in that, because you can be prosecuted under the law. But there are sufficient safeguards. And on that note, Senator Seepersad, the Cabinet did approve the 2017 Intercept report, and it was only in the last 20 months ago, because it was prepared months ago, at least 6 months ago, if I remember correctly. And it is only within the last 24 hours, when the Attorney General was doing the same research you were doing, that we realized that it got stuck and it wasn't laid. And I apologize for that. With all of the reports, we were the ones that did it from prior to 2015. We got it up to 2017. The 2018 is currently being prepared. I told them to write to the various 3 individuals I've just listed and tell them I want those statistics in for the exact same reasons you have listed, because it is for accountability. And I told them, by the way, you have a few days left for 2019. So let me get now to some of the protection. If you go to section 23 because it's important to just remind ourselves what exists in the law. Section 23 of the current Act, the Parent Act, 23(2) says, a person who intentionally discloses the contents of any communication, either obtained by a means of warrant or obtained in the course of interception of communication, and it makes it a criminal act. There is the protection in the Act. So exactly as Senator Seepersad said, Madam President, this is no longer time for old talk and grand charge and politicking. We're dealing with a very specific subset of criminality that is prevalent, too prevalent, in our prison system. And that is what these amendments are here to do today. So I assure the population that under the parent legislation, sufficient protection exists to ensure there is not an abuse of the intercept. Does it mean that persons may not abuse it? No, it doesn't. Because once you have human elements, there's always that possibility. But is there sufficient protection in the legislation? The answer is yes. Because persons can be prosecuted, and it is narrowed to 3 persons can start the interception. You have the courts overlooking the approval of warrants, and that is part of the amendment process here today, to make that process more relevant. Because another thing with crime and criminality, like everything in life, there's no mold growing on the stone. Crime and criminality, exactly as you identified, Senator Seepersad, is marching very strongly along. And if we don't provide the law enforcement agencies and our intelligence agencies with these amendments here, they are going to be left behind, and the only people that suffer are the law-abiding citizens. Because by definition, the criminals don't care about the law. So again, I put on alert the population. Why would anyone, any single citizen, want to try to protect an illegal mode of communication of prisoners in a prison using contraband phones? The importance of Intercept is it boosts investigative and evidence-gathering capabilities, and that's what we need. As I just said, crime and methods of criminality are always evolving. Madam Speaker, Madam President, at this time, these amendments are vital to the fight against criminality in Trinidad and Tobago. And let's with that now move to the prisons and a little bit of what is going on in our prison system. Not today, but for far too long. We are able, through the technology that exists, to pick up the fact that persons are communicating and trying to communicate via modes of communication, either phones, tablets, hotspots, with persons on the outside. What we did a few months ago in the passage of the miscellaneous provisions of Law Enforcement Officers Amendment Act was make it a crime. Today, we take that fight further. And we're saying to those who participate in this type of behavior, those who may be communicating with persons who are incarcerated, some of them for murder, and helping them to carry out their criminal acts and activities, we know you're doing it. When we pick you up for it, we can now charge you for it, and charge both of them. That must become a deterrent, because there are all sorts of people, some in our midst and some outside, who are conducting themselves in this manner, and it is unacceptable. As the Minister of National Security and as a concerned citizen, I repeat, there is no legitimate reason for anyone to be communicating with a prisoner other than through the legal and designated means which are sufficient. So for anyone to suggest there must be protection of a prisoner using a contraband phone to communicate, that's a person who needs to be watched very carefully. Let's talk about what's going on in the prison system. Gang activity, instructions to gang members on the outside. It is a reality. You have incarcerated prisoners giving instructions via illegal means, illegal cell phones, to persons on the outside to do all sorts of things, including the continuation and conduct of criminal empires. And if we don't pass this type of legislation, what we're doing is we're condoning that as continuing. But if we pass this type of legislation, we're making it an express act of criminality. And we're saying we're not going to accept that as a society. And that is what we're being called upon here to do here today. So when you go to some of the amendments, first of all, this is not open-ended. We've limited the type of proceedings that the amendments will carry through to. And this act applies to criminal proceedings, proceedings under the Proceeds of Crime Act, proceedings under the Extradition, Commonwealth and Foreign Territories Act, proceedings under the Anti-Terrorism Act, proceedings under the Civil Asset Recovery and Management and Unexplained Wealth Act. All legitimate. Nothing further than that. Very closely confined parameters as to what this should apply to. In the definition section, we're very, very careful about the expansion of what is covered. Because you see, technology changes. Because even if you think 5 years ago, even on your cell phones and the advent of smartphones, there weren't these type of end-to-end encryption platforms, the WhatsApp and the Signal and the Telegrams. There also were other ways of communicating. It was just a strict pick up your phone, call from number to number. But now we must cater. Because sometimes I heard it mentioned by Senator Sobers a little while ago, asking, well, why would you want stored information? Why wouldn't you? We have had many a breakthrough in many a criminal investigation when you pick up the devices of those engaged in criminal activity and you're able to forensically image it and pull out of that what are the types of communications taking place. The difference that these amendments propose today is to make that criminal evidence now for criminal prosecution. So when you pull a device of persons in a carnival terror threat and you see some of what they had, how to attack a convoy, how to make a bomb using things you can buy in a hardware, what are the travel routes of certain people? Why shouldn't we allow law enforcement now to use what was picked up from that device as evidence in a criminal case? Because as you said, Senator Seepersad, we can no longer rely on human witnesses who may be threatened and who may feel afraid and witness statements. But let us put the criminals on the back foot. Let them explain why they have this type of information and plans on their devices, especially the ones in prison. Just to go very quickly to the conversation about prisons, if I may, through you, Madam President. Because you see, this isn't a new or local phenomenon. I just want to refer to 2 articles. The first is entitled Contraband Cell Phones in Prisons Quickly Becoming a National Crisis by Ann Emerson on the 12th of December 2018. I repeat the title. Contraband cell phones in prisons quickly becoming a national crisis. This isn't Trinidad and Tobago. In Washington, St. Clair Broadcast Group, cell phones are just about everywhere these days, including, it turns out, our nation's prisons. They're dropped in by drones, thrown over jail walls, and even smuggled in by correction officers. And it's all illegal. This is in Washington, D.C., talking about nationally in the United States in December 2018. So don't come with the old talk that this is Trinidad and Trinidad alone. That's one article, Madam President. The second one, How Prison Telecommunications Work by Jane McGrath. Cell phones in prison, contraband. Another way for inmates to dodge prison eavesdropping is to gain their own phones, and that's what I'm hearing here today. I'm hearing the suggestion, allow them to continue. Prison authorities have found it surprisingly easy for prison inmates to get their hands on working cell phones with chargers to boot. One tip-off came from an inmate's mother who wrote to a warden in Texas prison complaining that her son's cell phone reception was bad. That is how ridiculous it is. I see Senator Choate smiling. I will tell the population here today that on the weekend provided to me as Minister of National Security was a voice note sent by a prisoner giving me his cell phone number, saying, call me, we need to have a conversation. That is what is going on. And now what we are trying to do is criminalize that, because it is unacceptable for this to continue. Because exactly as the Attorney General has said, what does take place is the continuation of a criminal empire. There is no doubt. Senator Sober has reminded us that on the last occasion, one of his pertinent parts of his contribution was how disturbed he was finding out of a criminal incarcerated calling a hit on someone. What we can do when we pass these amendments today is make that an illegal act, because we can now use the evidence, whereas before we couldn't. But there was some difficulty with respect to it. Just to carry on with this, cell phone accessibility has become a serious problem for prisons. In addition to the crimes that inmates are known to commit over the phones, gangs can organize themselves far more easily when members in prison have cell phones. For example, in 2006, incarcerated gang leaders in Brazil orchestrated large synchronized riots using their cell phones, reportedly in order to prove their influence even behind bars. The gang caused uprising in more than 70 prisons, and meanwhile, members outside of the prison caused riots and wreaked havoc on public buses and police stations. Gangs transcend prison bars in the United States too, where gang leaders have been able to wield their power from inside prison walls, even ordering gang murders. So this is not a phenomenon that is only about Trinidad and Tobago. It is something every national security apparatus is facing all over the world. The difference is in their legislatures. The law is passed criminalizing this. In the United States, you can't have a cell phone in a prison. But we're hearing here today, you should allow that to continue in Trinidad. And I say, as a citizen who is concerned for the safety and security of all of our law-abiding citizens, and as the Minister of National Security, that is unacceptable. At the prisons, we have been doing a lot more work. You all would have been seeing as the public, because I've asked them to notify the public via the relevant releases. We're doing a lot more searches, and we have been picking up. The Friday last week, due to a sting operation, a particular prison officer was caught and is being charged, or has been charged, for bringing contraband into the prison, including these same cell phones. But we need this legislation to help us in the fight, to convert what is going on to evidence that can be used to prosecute these persons for the criminal acts that they continue to carry out. Our Intercept has saved lives. Through the Intercept that has taken place, we have managed to save the lives of persons by picking up some of the orders of hits that have gone on. A few weeks ago, a gentleman came up to me and he said, "Mr. Young, I love you." I said, "Okay." He said, "No, I really do." I said, "Okay, sir." He said, "You don't know who I am." I said, "No, I don't." He's a taxi driver. He then told me, "My son is a prison officer." I said, "What's your name?" He told me his surname. He said, "Do you know what you've done for my son?" I said, "Sir, we did it twice. Because of what we managed to pick up, we managed to save his son's life on 2 occasions because of the illegal contraband cell phones in the prison." He then called his son and put his son on to me, and I said, "Officer X," because I remember the incident, and they expressed gratitude. But that's not gratitude to me. That's gratitude to the law enforcement officers and our intelligence agencies, who are the ones asking for this legislation. Because you know what? Yes, we saved the life twice, but we can't prosecute them based on the intercept that was picked up. But with the passage of this legislation, you can. And when persons inside realize, I ain't getting back outside, because if I continue with this type of behavior, my stay here is going to be longer. it will have the deterrent effect. And you can also prosecute them for attempted murder. So to listen to why we shouldn't do that today, I find offensive. Let me just quickly respond to a couple of things that were raised, lest our population be misled. This whole boogeyman, as we call it in Trinidad, of professional legal privilege. There is nothing in this legislation, nothing, Madam President, that affects a prisoner's legal right to a continuation of legal professional privilege. Nothing. A complete fear-mongering, a boogeyman, a throwout of misinformation that is synonymous with the opposition now. Everything in these amendments provides for the protection of continued legal professional privilege. But what it will no longer permit, and it now makes criminal, if and when passed, is for lawyers to have conversations using illegal contraband cell phones with prisoners. Come into the prison, send your junior to get instructions. There are designated areas. There are also landlines that the prisoner can call you. All of that is there. Why would you want to protect? And I'll tell you why. It isn't evidence because we don't have the act. But there has been intercept of certain lawyers practicing at the criminal bar, communicating openly with the most notorious of criminals on the inside. Through the same intercept, as well as what we've gotten off stored devices. If those conversations ever became public, the public would be shocked. And I remember saying this about 18 months ago, and being attacked by the Law Association doesn't bother me. Because every time I say something, I have the supporting information for it. 6 senior counsel calling upon me to apologize. If you have the information, take it to the police. It's the police I got it from. But that is what is going on. And lawyers conducting criminal empires for their clients, not taking instructions as to how to conduct their defense. I want you to go out there and pay X. Go and tell Shorty and Redo and tell Shooter, I want this one dealt with and that one dealt with. Pass this legislation today, we'll deal with them. Because now we could use them through due process, charge them for it, put them before the court. Let them now go and explain to the jury and to the court why they were listening to a criminal and conducting the exercise for the criminal as to when that criminal was telling them what to go and do. That is not legal professional privilege. And the amendments protect lawyers in their privileged conversations with clients. I want to remind persons at this time, Madam President, that the Act also provides very, very clearly, the Parent Act, that if you intercept and you pick up information that is not pertinent to the warrant or what you're looking at, you have to destroy it immediately. Section 20. So the Parent Act provides the safeguards. You can't keep that indefinitely. The officer is compelled, mandated to get rid of that communication that has nothing to do with the investigation. But that is some of the behavior that is taking place, Madam President. Knee-jerk reaction, typical language. This legislation is not knee-jerk. It's been worked on for a long time. It is well thought out, and there is nothing that is knee-jerk about it. Consultation. I smiled when I heard about the suggestion of who should be consulted with, the prisoners? Who should be consulted with, the prisoners? Even the Law Association. The Law Association who didn't give their view. There is nothing legitimate about speaking on a contraband cell phone with anyone from within a prison wall. Who is there to consult with? What, ask the prisoners, should you be allowed to speak to Senator X? Because that is what is going on. So who should the consultation take place? With the greatest of respect, a ridiculous point and a red herring. Have issues designated
Madam
areas,
President,
how many
standing
times
order.
are not available?
Standing order, raising a point of order. Standing order 46 for Madam President. It's very offensive, the conduct of the minister.
Minister, continue, please.
Thank you very much. Have issues with designated areas many times not available? Would those areas be subjected? Would these areas be subject as designated areas? The legislation is clear as to where the minister can declare to be an area or not. All of our prisons have working infrastructure. This doesn't include police stations. In the definition of prisons, it does not include police stations. So I don't know where Senator Sobers was going with that. Well, it does, a holding cell at a police station. But again, a prisoner in a holding cell of a police station should have a phone? Is that what's being suggested? Also, another red herring, set out how long warrants for intercepts are. Every single warrant has a deadline. The maximum that you can intercept someone for is 90 days, and you have to go to a judge to get it. You can try to renew after that, it's up to the judge. But again, it is the minister who gets an account, who gets a report as to every single intercept. And if something is amiss there, ask the questions. This is a system that has been in place since 1995. So don't raise that. These are the legitimate interceptions. And under this administration, that is what exists. Certainly, I can say as the Minister of National Security, that is what exists.
Minister, you have 5 more minutes.
Thank you very much, Madam Speaker. This dog whistle, because that's always part of the strategy. The dog whistling, is this a sinister approach? Is this for individuals behind prison walls? The answer is yes. But are there persons who may be communicating with those behind prison walls that are nervous? Good. Because you shouldn't be talking to them. You shouldn't be having a prisoner who is in there for murder give you instructions as to what to do. Because no law-abiding citizen wants, and I'm not dog whistling, you know. That is a fact. So don't come with a dog whistle. Is there a sinister approach? The answer, senators in Trinidad and Tobago, is no. The law enforcement officers are asking for this to fight the phenomenon of what we're facing with prisoners talking. And this goes to prisoners talking in the vans to and from prison as well. This one was good. Prison is a prison is a prison. Shouldn't allow cell phones, but there's no but. Yes, a prison is a prison. Your rights are curtailed, and we have provided for lines of communication with your family, your lawyers, etc. So there is no but. Only defense is a lawyer. Are we going to trample on his or her rights? To have a cell phone in prison is illegal. It's contraband. No rights being trampled on. Prior to cell phones, as I said a short while ago, how did prisoners speak to their lawyers and their families? And we have those facilities in the prison. Senator Seepersad, I agree with you that legislation alone will not suffice. And that is why we need to do this. And as you accepted, this is merely one tool in the toolbox and one step forward in the fight against crime and criminality. So, Madam President, as the Attorney General said, the time allotted to us is not sufficient. But I've come here today as a concerned citizen and as your Minister of National Security to ask for your support for the passage of this critical piece of legislation to allow our law enforcement officers that one tool in their toolbox to continue in the fight against criminality. And the particular criminality that we're facing down here is those within the prison walls. Madam President, I thank you.
Honourable Senators, the sitting will now be suspended. We will return at 5:10 p.m. and Senator Hussain will be making his presentation when we resume.